All right, good morning, everyone. It's 9 o'clock, so we will go ahead and begin. Let's come to order and go on the record, please. I'm Charlotte Mitchell, Chair of the North Carolina Utilities Commission. With me this morning are the following commissioners. When I announce your name, please indicate your presence. Commissioner Tanola D. Brown-Bland.
Present.
Commissioner Lyons Gray.
Good morning.
Commissioner Daniel G. Clodfelter.
Yes, good morning.
Commissioner Kimberly W. Duffley.
Good morning.
Commissioner Jeffrey A. Hughes.
Hello, I'm here.
And Commissioner Floyd B. McKissick, Jr.
Present. Good morning.
All right, I now call for hearing docket number E7 sub 1214, the application of Duke Energy Carolinas LLC for an adjustment of rates and charges applicable to electric utility service in North Carolina. Docket number E7 sub 1213, which is the petition of Duke Energy Carolinas LLC for approval of its prepaid advantage program. And docket number E7 sub 1187, which is the application of Duke Energy Carolinas LLC for an accounting order to defer incremental storm damage expenses incurred as a result of Hurricanes Florence and Michael and Winter Storm Diego. The latter two dockets have been consolidated for hearing with the general rate case docket by orders of the Commission. On September 30th, 2019, DEC filed an application with the Commission in docket number E7 sub 1214, requesting authority to adjust and increase its rates for retail electric service in North Carolina. On October 29th, 2019, the Commission issued a scheduling order establishing the general rate case, suspending rates, scheduling hearings, and requiring public notice. Pursuant to the scheduling order, the Commission held several public witness hearings in DEC's service area in order to receive evidence in the form of testimony from DEC's customers. The scheduling order also set an expert witness hearing to commence on March 23rd, 2020. Due to the state of emergency that has been declared in North Carolina to coordinate the response and protective actions to prevent the spread of the novel coronavirus and the associated restrictions on mass gatherings, the expert witness hearing was postponed by order of the Commission dated March 16, 2020. On March 25, 2020, DEC and the public staff filed their first agreement and stipulation of partial settlement in this proceeding. On June 17, 2020, the Commission ordered that the expert witness hearing in DEC's rate case and the expert witness hearing in the rate case of Duke Energy Progress LLC, which was filed on October 30th, 2019, and docket number E2 sub 1219, be consolidated for the purpose of receiving expert witness testimony on several specific topics. The consolidated hearing was initially scheduled to commence on Monday, July 27th, 2020, but by subsequent orders of the Commission, the consolidated DEC and DEP hearing was rescheduled to begin on Monday, August 24th, 2020. On July 31st, 2020, DEC and the public staff filed their second agreement and stipulation of partial settlement along with supporting testimony. On August 6th, 2020, the Commission issued an order approving DEC's public notice and financial undertaking relating to DEC's exercise of its statutory right under North Carolina General Statute 62-135 to place into effect temporary rates pending a final order by the Commission approving permanent rates. From August 24th through August 31st, 2020, the Commission held the consolidated DEC and DEP hearing and received evidence from expert witnesses on several specific topics. On August 31st, 2020, the Commission issued an order setting the separate DEC expert witness hearing to begin on September 3rd at 9 o'clock in the morning. The Commission has allowed intervention in these dockets upon petitions filed by each of the following parties: Harris Teeter, the North Carolina Clean Energy Business Alliance, the North Carolina League of Municipalities, Apple, Facebook, and Google, the Carolina Industrial Group for Fair Utility Rates 3, the Center for Biological Diversity and Appalachian Voices, Carolina Utility Customers Association, Inc., the Commercial Group, the North Carolina Justice Center, the North Carolina Housing Coalition, the Natural Resources Defense Council, and Southern Alliance for Clean Energy, NC Warren, Inc., the North Carolina Sustainable Energy Association, the Sierra Club, and Vote Solar. DEC has entered into partial settlements with Harris Teeter, the Commercial Group, Sigford, Vote Solar, and jointly with NCSEA, the North Carolina Justice Center, the North Carolina Housing Coalition, the Natural Resources Defense Council, and the Southern Alliance for Clean Energy. In addition, numerous statements of position from DEC's customers have been received by the Commission and filed in the official file for each of the DEC dockets. That brings us to today. Before we get started, I want to make a few points on the record in light of the fact that this hearing is being conducted remotely. This hearing has been made accessible to the public by way of a link to a video stream that's provided on the Commission's website. Each of the parties has consented to the Commission's conducting this hearing by remote means, as evidenced by the parties' filings in these dockets. In the interest of ensuring the efficient use of hearing time and minimizing the potential for technical difficulties, the Commission has provided multiple opportunities for the parties to verify that they're able to access the remote technology utilized by the Commission for this hearing, including technology checks conducted on July 21st, 22nd, and 24th. Due to the fact that this hearing is being held remotely, parties have been asked to avoid the use of confidential information to the greatest extent possible. In the event that a party must reference confidential information during testimony, we will leave the video conference and join a teleconference line. The party whose confidential information is discussed is responsible for ensuring that only those parties who have executed confidentiality agreements are on the teleconference line. When discussion of the confidential information is complete, we will leave the teleconference line and go back on video conference. Okay, let's begin. Pursuant to the State Ethics Act, I remind all members of the Commission of their duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has a known conflict of interest with respect to the matters coming before us this morning. The record will reflect that no conflicts have been identified, so we will proceed. I call upon the parties to indicate their presence this morning, beginning with the applicant.
Yes, good morning, Chair Mitchell, members of the Commission. My name is Kamal Robinson, appearing on behalf of Duke Energy Carolinas. Chair Mitchell, would you like me to introduce the attorneys again?
Please do so, Mr. Robinson, simply for the purpose of allowing everyone to know who's on the line and who will be present for the company.
Absolutely. So also appearing with me, Chair Mitchell, from Duke are Mr. Bo Summers and Mr. Brian Heslin. Additionally, we have appearing with us from the law firm of Troutman Pepper, Kiran Mehta, Molly Jagannathan, and Brandon Martzo. Mr. Martzo is a member of the Georgia Bar and has pro hoc vice motions granted for appearance in this proceeding. We also have appearing from the law firm of McGuire Woods, Jim Jeffries, and Andrew Kells. All of our attorneys have filled out appearance sheets and have provided them to the court reporter.
All right, thank you, Mr. Robinson. All right, turning to the interveners, public staff.
Good morning, Chair Mitchell. Diana Downey, Chief Counsel of the Public Staff, appearing on the Using and Consuming Public. Appearing during the course of this hearing will be Elizabeth D. Culpepper, Layla Cummings, Tim R. Dodge, Lucy E. Edmondson, William E. Grantmeyer, Gina C. Holt, Megan Yost, John D. Little, and Nadia L. Lohr.
All right, thank you, Ms. Downey. The Attorney General's office.
Good morning, Madam Chair. This is Margaret Force with the Attorney General's office, and also appearing with me is Teresa Townsend on behalf of the Using and Consuming Public.
All right, thank you, Ms. Force. Kuka.
Good morning, Chairman Mitchell and Commissioners. Bob Page appearing for Carolina Utility Customers Association.
Good morning, Mr. Page. Sigfer.
Good morning, Chair Mitchell. This is Christina Kress with the law firm of Bailey and Dixon. I am appearing on behalf of the Carolina Industrial Group for Fair Utility Rates 3, otherwise known as Sigfer 3, or for short, Sigfer.
Thank you, Ms. Kress. Center for Biological Diversity and Appalachian Voices.
Good morning, Chair Mitchell and Commissioners. My name is Jean Sue with the Center for Biological Diversity, appearing on behalf of the Center for Biological Diversity and Appalachian Voices. Appearing with me today is my co-counsel, Howard Crystal, also with the Center for Biological Diversity.
Good morning, Ms. Sue.
Good morning.
The Commercial Group.
Good morning, Chair Mitchell, Commissioners. Alan Jenkins for the Commercial Group.
Good morning, Mr. Jenkins. Harris Teeter. All right, the North Carolina Justice Center.
Good morning, Chair Mitchell. My name is David Neal at the Southern Environmental Law Center. appearing on behalf of the North Carolina Justice Center, North Carolina Housing Coalition, Natural Resources Defense Council, and Southern Alliance for Clean Energy. Appearing with me, also from the Southern Environmental Law Center, Gudrun Thompson and Tyrell Moore.
Good morning, Mr. Neal. All right, NC Warren.
Good morning, Chair Mitchell and Commissioners. This is Matthew Quinn. I am here on behalf of NC Warren.
Good morning, Mr. Quinn. NC Seba. All right, North Carolina League of Municipalities. NCSEA.
Good morning, Chair Mitchell. Peter Ledford on behalf of NCSEA. With me is my co-counsel, Ben Smith.
Good morning, Mr. Ledford. The Sierra Club.
Good morning, Chair Mitchell and Commissioners. Bridget Lee of the Sierra Club, appearing on behalf of the Sierra Club, and with me today, Catherine Crawley-Jones of the law offices of Brian Bryce.
Good morning, Ms. Lee. Tech customers.
Good morning, Chair Mitchell and Commissioners. I'm Marcus Trathan with the law firm of Brooks Pierce, appearing on behalf of the tech customers, Apple, Facebook, and Google. Also with me are my colleagues, Craig Schauer and Matt Tynan.
All right, good morning, Mr. Trathan. All right, and Vote Solar.
Good morning, Chair Mitchell. Thad Cully appearing on behalf of Vote Solar.
Good morning, Mr. Cully. All right, any preliminary matters that the commission should take up prior to moving into the hearing?
Yes, Chair Mitchell, the company has about 5 matters to bring up, so I'll start with the beginning.
All right, you may proceed, Mr. Robinson.
Thank you. So Chair Mitchell, out of an abundance of caution, the company renews its motion from the consolidated phase of the hearings to enter into the DEC record the company's application, Appendix A, as well as Exhibits A through D. In addition, E1 items, including the corrections to items 14, 23, 33, and 38. In addition, the settlement agreements for DEC specific, as well as the pre-filed testimony of excused witness John Panizza. Also, the pre-filed testimony and exhibits of the following witnesses who appeared during the consolidated hearing: Dylan DeSendis, Carl Newland, Steve Young, Jane McManus, Jay Oliver, and Kanisha Barnes.
All right, Mr. Robinson, hearing no objection to your motion, it will be allowed, and I will for purposes of the record, the testimony of the DEC witnesses that was admitted during the consolidated hearing will be copied into the record at this time.
Thank you, Chair Mitchell.
All right.
Next on my list, on July 16th, 2020, the Commission granted the company's motion to excuse the following witnesses from appearing in the DEC proceeding. Those witnesses are Stephen Capps, Kimberly McGee, Rufus Jackson, Renee Metzler, Teresa Reed, and Rudolph Bonaparte. Subsequently, on August 13th, 2020, the Commission granted the company's motion to excuse from the DEC proceeding Dylan DeSendis and Zachary Kuznar. Therefore, at this time, we ask the following testimony and exhibits be moved into the record: the direct testimony and exhibit of Kimberly McGee, the direct testimony and 2 exhibits of Rufus Jackson, the direct testimony and 1 exhibit of Teresa Reed, the rebuttal testimony of Renee Metzler, the rebuttal testimony and 2 exhibits of Rudolph Bonaparte, the rebuttal testimony of Zachary Kuznar, and the direct and rebuttal testimony of Stephen Capps.
All right, Mr. Robinson, hearing no objection to your motion, the testimony of and exhibits of those witnesses that has been pre-filed will be admitted into the record of this proceeding and will be copied into the record at this time.
Thank you, Chair Mitchell. The company also notes for the record that while Mr. Capps has been excused on August 13th, 2020, the Commission granted the company's request to recall witness Stephen Capps if needed as a result of the public staff's ongoing audit of the company's proposed adjustments through May 2020. just a note. Chair Mitchell, next on my list, due to some anticipated scheduling conflicts, the company seeks to reorder its 8 witnesses appearing during the rebuttal phase of our case. The company seeks to reorder its witnesses during that phase as follows. The Doss and Spanos panel to be first, followed by Sean Riley, followed by Eric Leoy, followed by Jessica Bednarsik on rebuttal, followed by Stephen Fetter, and then followed lastly by the Jim Wells and Marshall Williams panel. Provided the commission has no issues with this reordering, the company will file an updated version of the spreadsheet reflecting these changes by close of business today.
Thank you, Mr. Robinson. The commission has no issue, takes no issue with the reordering of the witnesses as you've indicated here this morning, but I do request that you file the updated order of witnesses before the close of the business today.
Thank you, Chair Mitchell. Okay, next on my list, these are more notations. Wanted to flag for this commission that the company's original printed version of DEC potential cross exhibits 1 through 3 had some formatting issues with pagination. Again, this is the printed version, not the electronic version. Since then, the company reprinted corrected versions of potential cross exhibits 1 through 3 and delivered them to each commissioner. It is my understanding that all commissioners did receive the corrected version and just ask the commission to please refer to the corrected versions of those exhibits at such time if the company chooses to introduce them.
All right, thank you, Mr. Robinson.
Thank you. And then last on my list, Chair Mitchell, wanted to quickly provide the commission a status update on the 6 late filed exhibits that were requested during the consolidated phase of the hearing. The company filed late filed exhibit number 1, the FFO to debt hypothetical, on September 1. In addition, the company is on track to provide most of the remaining late filed exhibits by the end of this week and any last ones by early next week. And that's it.
All right, thank you for that update, Mr. Robinson. All right, anything further from Duke at this time?
Nothing from Duke.
Okay, any additional preliminary matters from other parties?
Madam Chair, Alan Jenkins for the commercial group. All parties have waived cross-examination of Steve W. Chris, and therefore I move into the record his direct testimony consisting of 18 pages of testimony with an Appendix A and 4 exhibits pre-marked as Chris exhibits 1 through 4.
All right, Mr. Jenkins, I appreciate your motion, and you've reminded me that I need to make one more sort of housekeeping point. So at this point, I would like for you to hold your motion and renew it once we have completed the examination of Duke's witnesses offered on direct. And at that time, when we move into the examination of the expert witnesses offered by the intervening parties, I'll entertain your motion.
Thank you.
And you know, that's just and that would pertain to any party, any intervening party at this point in time. So just for purposes of the record, we will entertain motions from intervening parties subsequent to the presentation of Duke's direct. All right, any additional preliminary matters from the parties?
Chair Mitchell, this is Christina Kress with SIGPER. Do interveners need to submit a separate appearance slip for the DEC and DEP specific hearings if they've already submitted one that was to pertain to both dockets in the consolidated hearing?
If you have submitted your appearance sheet in the consolidated hearing, you do not need to resubmit an appearance sheet for the separate proceeding.
Perfect, thank you.
Any additional matters from the parties before we begin? All right, hearing none, the case is with Duke. You may proceed, Mr. Robinson.
Thank you, Chair Mitchell. At this time, the company would like to call witnesses Mr. Stephen DeMay and Mr. Larry Hatcher to testify as a panel.
All right, let me make sure I see Mr. Hatcher. And there you are, Mr. DeMay. All right, good morning, gentlemen.
Good morning.
Go ahead and get you under oath, please. Raise your right hands. Do you affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you very much. You may proceed.
Thank you, Chair Mitchell. I will start with Mr. Stephen DeMay first. Mr. DeMay, would you please state your name and business address for the record?
My name is Stephen G. DeMay. My business address is 410 South Wilmington Street, Raleigh, North Carolina.
And by whom are you employed and in what capacity?
I'm the North Carolina president for Duke Energy Carolinas.
On September 30th, 2019, did you cause to be pre-filed in docket E7 sub 1214 direct testimony consisting of 14 pages?
Yes,
And did you on March 4th, 2020, cause to be pre-filed in that docket rebuttal testimony consisting of 12 pages?
yes, I did.
Mr. DeMay, if you don't mind, you mind just speaking up a little bit? Thank you.
Yes, I did.
Do you have any changes or corrections to your pre-filed direct or rebuttal testimony?
No,
And if I asked you the same questions here today, would your answers be the same?
they would.
Mr. DeMay, did you on March 25th, 2020, cause to be pre-filed in this docket partial settlement supporting testimony consisting of 7 pages?
Yes, I did.
And did you on July 31st, 2020, cause to be pre-filed in this docket second settlement supporting testimony consisting of 9 pages?
Yes,
Do you have any changes or corrections to your pre-filed partial or second settlement supporting testimony?
no,
And if I asked you the same questions here today, would this be the same?
yes,
Mr. DeMay, did you prepare a witness summary for purposes of this hearing?
I did.
Chair Mitchell, at this time, I would move that Mr. DeMay's pre-filed testimony as previously described and Mr. DeMay's testimony summary be entered into the record as if given orally from the stand.
All right, hearing no objection to your motion, Mr. Robinson, it will be allowed.
Thank you, Chair Mitchell. I will move on to Mr. Hatcher next. Mr. Hatcher, would you please state your name and business address for the record? You're on mute, Larry.
Sorry about that. So Larry Hatcher, my address is 400 South Tryon Street, Charlotte, North Carolina.
By whom are you employed and in what capacity?
I'm employed by Duke Energy and I'm the Senior Vice President of Customer Services.
Mr. Hatcher, on December 20th, 2019, did you cause to be pre-filed in docket E7 sub 1214 direct testimony consisting of 32 pages?
Yes, sir.
And did you on March 4th, 2020, cause to be pre-filed in that docket rebuttal testimony consisting of 3 pages?
Yes, sir.
Do you have any changes or corrections to your pre-filed direct or rebuttal testimony?
No, sir.
Mr. Hatcher, if I asked you the same questions here today, would your answers be the same?
Yes, sir.
Did you prepare a witness summary for purposes of this hearing?
I did.
Chair Mitchell, I would move that Mr. Hatcher's pre-filed direct and rebuttal testimony and testimony summary be entered into the record as if given orally from the stand.
No objection, Mr. Robinson, to your.
Thank you, Chair Mitchell. The panel is now available for cross-examination.
All right, my notes indicate that we will begin with the Attorney General's office.
Thank you, Chair Mitchell.
Good morning, Ms. Townsend.
Good morning, gentlemen. My name is Teresa Townsend. I am with the Attorney General's office. Most of my questions will be, all of my questions will be for Mr. DeMay, and Ms. Force will direct questions to Mr. Hatcher when I am done. Mr. DeMay, on page 3 of your direct testimony, you listed several responsibilities of your position as North Carolina President for Duke Energy since you took that position in November of 2018, correct?
Correct.
In that list, you don't mention any responsibility regarding litigation, either brought on behalf of the company or against the company. Would you describe your role, if any, when litigation is brought against the company or when the company brings litigation against a third party?
My role is limited when it comes to litigation, Ms. Townsend. I, of course, am responsible for the performance and issues that arise and the regulatory and governmental affairs success of our 2 utilities here in North Carolina. When litigation is entered into or we are on the receiving end of litigation, I am made aware of that litigation generally when it rises to a level of materiality, and I will be updated on that periodically when there are updates, material updates to be made. But that would be the extent of it. If decisions have to be made, either settlement decisions or any other decisions related to litigation, I will be involved in those discussions.
Thank you. At the moment, there is litigation, active litigation going on and or that have recently been settled. Is that correct?
Are you there's a lot of litigation. Are you speaking with regard to coal ash?
Yes.
Okay, that is correct.
Okay. If I may go through the lawsuits that which I'm aware, and if you could provide us an update or a status report on that litigation as best you know it. I understand you don't know. I'm not asking for leads. I'm just asking in general what the status of this lawsuit.
If you're referring to the litigation where Duke is suing a group of insurance companies, are you referring to that?
We will get there, yes. Let me go through the list, starting with the 2013 action that was brought against Duke by DEQ. And that was about unpermitted discharges of wastewater via seepage, plus the 2L groundwater exceedances at 6 DEC plants, correct?
I'm not aware of that litigation.
Okay.
Specifically.
I'm sorry, I didn't mean to interrupt. Is that not part of the 12/31/19 settlement agreement? That action? To your knowledge?
I don't know.
All right, we'll get there. The second lawsuit was brought in February of 2017 by a Dr. Nigel and Donna Buste, alleging a lost sale of their property, excuse me, and property diminution due to the alleged stigma of the Dan River coal ash spill in February of 2014. Do you know anything about that litigation?
Not specifically.
But that was brought to a head and it was settled, correct?
Ms. Townsend, I'm not familiar with these lawsuits that you're naming.
Okay, let me try the next one for you. In February again, in 2017, there was a suit brought against DEC by individuals owning property in very proximity to the Dan River plant for private nuisance, trespass, negligence, gross negligence, and willful misconduct, and violations of the North Carolina Oil Pollution and Hazardous Substances Control Act related to the coal ash spill from the river plant. Are you familiar with that lawsuit?
I am vaguely familiar with that lawsuit because I recall that it occurred, but I don't have any updates for you.
Okay, so you don't know if it was settled?
I don't.
Ms. Townsend, I apologize. I'm going to interrupt you. Mr. DeMay, would you please adjust the volume of your mic or move it closer to you if that's possible? It's your volume is just is low, and I want to make sure the court reporter and the parties can hear you.
I'm going to try earbuds to see if that improves it.
Ready to try them out?
All right, Mr. DeMay, let's see if that's an improved situation. Can you, let's just hear from you for a test.
You're on mute, Mr. DeMay.
Can you hear me now? Is this any better?
It may be better. Let's go ahead and proceed. Please proceed, Ms. Townsend.
Thank you. In talking about the lawsuit you mentioned came in March 2017 when DEC filed suit for recovery under, I believe there were 38 excess level third-party liability insurance policies issued between 1971 and 86, alleging breach of contract for denying coverage related to CCR cleanup and at 15 power plants in North Carolina, South Carolina, arising out of CAMA and the federal CCR rule and South Carolina laws, seeking recovery of dollars already spent, as well as dollars to be spent in the future. Is that the case that you were referring to?
Yes, it is.
Okay. And going on in August of 2017, there was a class action suit in Wake County by Amy Brown against both DEC and DEP on behalf of property owners living near 9 coal ash impoundments at Allen, Asheville, Bellows Creek, Buck, Cliffside, Lee, Marshall, Mayo, and Roxborough for groundwater and contamination. Are you familiar with that one?
No, I'm not.
All right. And then on December of 2017, SCLC filed a citizen suit on behalf of Appalachian Voices, the North Carolina State Conference of the NAACP, and Stokes County branch of NAACP against DEC, alleging violations of the Clean Water Act related to alleged unpermitted discharges to surface water and groundwater violations at Bellows Creek Steam Station. Do you know about that?
I vaguely recall that lawsuit because the parties involved, but I do not have any update on it.
All right. And just two others. On December 15th, 2017, Cindy Braswell, a Plant Allen neighbor, filed a pro se complaint against DEC for alleged well contamination on 2 parcels of that land, of her land. Do you know anything about that lawsuit?
No.
All right. And last, on April 1st, 2019, DEQ ordered Duke Energy to excavate coal ash at 6 remaining sites in North Carolina. That was Allen, Bellows Creek, Cliffside, Marshall, Mayo, and Roxborough. Duke Energy filed petitions for contested cases in the Office of Administrative Hearings to appeal that order. You are familiar with that action, correct?
Yes.
All right. We mentioned the insurance lawsuit brought by Duke against some of its insurance carriers, correct?
Yes.
All right. Now, if I may refer to AGO Cross Exhibit 13.
I'm ready.
All right. Chair Mitchell, we would like to identify that and have it marked as the May AGO Direct Exhibit 1.
All right, Ms. Townsend, the document shall be marked May AGO Direct Exhibit number 1.
Thank you. And this is the March 2017 complaint of Duke Energy versus the insurance companies, correct, Mr. DeMay?
Yes.
All right. And on page 3, there is a section entitled Nature of the Action. Can you please read for us the paragraphs 1 and 2 related to that section?
Paragraph 1. This is a civil action seeking insurance coverage under certain third-party liability insurance policies, the policies, sold to Duke by the defendant insurance companies. Each of the policies provides coverage for liability for property damage caused by an occurrence. Paragraph 2. In particular, Duke seeks damages for breach of contract and an order declaring the present and future rights, duties, and liabilities of the parties under the policies and directing the defendant insurers to indemnify Duke for damages suffered by Duke from certain environmental claims, known as the environmental claims, asserted against Duke arising out of coal combustion residuals, CCRs, at 14 Duke power plants in North Carolina and 1 Duke power plant in South Carolina.
Thank you, sir. The only power plant not included was the WS Lee plant in South Carolina. Is that correct? Is that your memory?
Not included in what?
In the complaint, asking for relief.
Yes, I believe that may be true.
Thank you. The complaint provides some background on the environmental claims, starting on page 9 of the document. And paragraph 40, are you there?
I am.
All right. Paragraph 40 explains that power plants generating electricity through the combustion of coal create a number of waste byproducts, one of which is CCR, or coal combustion residual, more simply coal ash, yes?
Yes.
All right. Would you please read for the record how the company's complaint describes coal ash in paragraph 40? It's on page 10 if you want to start with the words coal ash, second sentence.
See, are you asking me to read to the end of that paragraph?
Yes, please.
Coal ash contains various heavy metals and potentially hazardous constituents, including arsenic, barium, cadmium, chromium, lead, manganese, mercury, nitrates, sulfates, selenium, and thallium. Coal ash has not been defined itself as a hazardous substance or hazardous waste under federal law, although some constituents of coal ash may be hazardous in sufficient quantities or concentrations.
Thank you, Mr. May. And if you would turn to paragraph 44 on page 11.
Okay, I'm there.
All right, it says, it's alleged without regard to historical awareness of harm that coal ash constituents from coal ash basins and other areas have been infiltrating into groundwater over a long period of time. State environmental regulators have alleged there have been environmental impacts or potential impacts to groundwater beneath each of Duke's North Carolina and South Carolina coal-fired power plants that are part of this claim. Have I read that correctly?
Yes, you did.
All right. And if we could move to paragraph 22 of the complaint, which is on, 52 of the complaint, which is on page 14.
I'm there.
All right. Starting with paragraph 52, it provides that the North Carolina power plants at which Duke faces liability on account of alleged environmental property damage allegedly caused by CCR are as follows. Correct?
Yes.
Right? And then they list Allen, Asheville, Ellis Creek, Cape Fear, Rogers, Dan River, H.F. Lee, Marshall, Mayo, Riverbend, Roxborough, L.B. Sutton, Webster, and H.B. Robinson in South Carolina, correct?
Yes.
All right. For each power plant listed, one of the paragraphs, like paragraph 55, states that Duke has incurred substantial cost on account of its liability for alleged CCR-related environmental property damage arising out of impoundments and or other areas at the Allen plant for which Duke makes a claim under the policies issued to Duke Power. Duke is incurring substantial additional cost on an ongoing basis and will continue to incur substantial additional cost in the future. Correct?
You read that correctly.
Thank you. Do you know what the current status of this insurance litigation is, Mr. May?
I do. They are in various phases of discovery. I understand that that will conclude this year. Hearings will begin in 2020, and a trial is expected to begin at the beginning of 2021.
Thank you. There have been some settlements, but those are confidential, correct?
You broke up. I'm sorry. There have been some settlements.
Right, but those are confidential. We will not get into those. Correct?
Confidential, but limited in nature and scope.
Thank you. Now, if I may refer you to an exhibit that's already in play, it is Public Staff Junus Direct Exhibit 1. That is the DEQ settlement agreement dated December 31st, 2019.
I'm sorry, Ms. I didn't catch the end of that.
That is the DEQ settlement agreement dated December 31st, 2019.
Thank you.
Thank you. Okay, Mr. DeMay, I believe you said that you were aware of the settlement agreement. Is that correct?
Yes, I am aware of the settlement agreement. I don't have it in front of me.
I'm sorry, you broke up. I missed you there.
I do not have it in front of me.
Oh, you don't have Junus Exhibit 1?
I'm going to try and pull the, to correct my audio. Just give me 1 minute, please. Ms. Townsend, would you please repeat the exhibit name? I apologize.
No problem. It is the 12/31/19 settlement agreement, and it has been filed under Public Staff Junus Direct Exhibit 1.
Okay, it's coming.
Thank you.
Okay, I have it.
Great.
Sorry for that.
No problem. What role, if any, did you have in negotiating the settlement, Mr. Nemay?
I was involved along the way.
Okay. Were any other staff members involved in the negotiation?
There were quite a number, and there were very technical details involved in the settlement that I had very little input on.
Understood.
So, and a limited understanding of it.
Okay. And this settlement is not only with DEQ, is that it's with, deals with some of those other lawsuits or disputes that we talked about earlier, correct?
Yes.
Okay, if we look at paragraph 5 on page 2, it talks about the litigation that is involved in this settlement, and that's quite a list. I believe that entails most of the ones that we talked about, correct?
I'll accept that, yes.
Thank you. So it looks like it was the 2 state law enforcement actions brought by DEQ. In fact, they talk about it in 6. It says it desires to resolve and settle any disputes between them in connection with the OAH proceedings, and that would be those 4/119 closure determinations, correct?
It would, yes.
All right. The state enforcement actions, those would be the ones brought in 2013 and thereafter. The Federal Clean Water Act lawsuit brought by FDLC. And then there are evidently some PGARs.
Excuse me. I hate to interrupt. Ms. Townsend, you're breaking up a little bit. I don't know if it's because there are more than one microphone on. Perhaps if we do alternating microphones, it may help the breakup a little bit.
Sorry. Okay.
No problem.
All right. So just to go back to paragraph 6, we dealt with the fact that they were the OAH proceedings, the state enforcement actions, the Federal Clean Water Act lawsuit, and PJRs, which are petitions for judicial review, in order to ensure that the impoundments are excavated on an expedited basis and to remove the uncertainty associated with litigation. Is that what paragraph tells us?
Yes, I see that.
All right. And then on paragraph 7, this talks about the actual impoundments at the facilities regulated under CAMA. And it deals with A, says it's about Allen. And it says Allen has 2 CCR impoundments, a retired ash basin and an active ash basin, and that it's approximately 123 acres. Correct?
That's what it says, yes.
All right. And then B was the Bells Creek Steam Station. C is the Cliffside Steam Station. And D is the Marshall Steam Station, correct?
Yes.
And then we have E and F being the Mayo and the Roxborough, correct?
That's correct.
DEP, correct?
Correct.
All right. And if we'll go to paragraph 50, which is on page 24, it states that DEQ is the only state entity that is bound by this agreement and consent order, correct?
Yes.
All right. And if we go to paragraph 53, it has some stipulations. I'm sorry, it's on page 25. Are you there?
I am.
All right. It talks about stipulations between only the parties to this agreement regarding the rate recovery proceedings, correct?
Yes.
All right. And it says on page 26 under the first full sentence, for example, and without limitation, the agreement in the subparagraph does not extend, nor shall it be construed to apply to the issues of 1, whether Duke Energy acted prudently and reasonably in the past, or 2, whether Duke Energy prudently and reasonably performs its obligations under this agreement. Is that correct?
It does say that, but it is saying that if we do perform these actions, that those are deemed prudent unless we imprudently execute on them.
By the parties to this agreement only, though, correct?
Yes.
All right. And that is all the questions I have, Mr. DeMay. Thank you for your patience and for your answer.
Thank you, Ms. Townsend.
And Ms. Force, as I said, has questions for Mr. Hatcher.
Good morning, Mr. Hatcher.
Good morning.
Me okay?
Yes, ma'am.
Let me know if I need to turn my mic on and off. I'm hearing a little feedback.
I'm hearing it too, Ms. Force, so I would ask that you all keep your lines on mute until the moment you need to speak, please. Thank you.
Okay. Mr. Hatcher, my name is Margaret Force. I'm with the Attorney General's office. And in looking at your testimony, I see that your responsibilities include customer care, online customer interactions, billing and metering services, and you also address some of the new features of the Customer Connect system. Is that right?
Yes, ma'am. Yes.
I think I only heard part of your answer, but it was a yes, ma'am, right?
Correct.
I have some questions about the technology that Duke is using with Customer Connect to help customers take advantage of emerging programs or apps that make use of the detailed data that Duke is collecting from customers' smart meters, the advanced meter infrastructure to monitor and conserve energy. And it looks like the questions are appropriate for you and for Mr. Schneider both. So I plan to start with you. But if you think that I need to ask another witness, just let me know who to ask, please. Okay?
Okay.
I see on page 4 of your direct testimony, starting on line 16, that you've stated that the customer is at the center of Duke's purpose and that evolving customer expectations, emerging technologies, and changing public policies all converge to create a dynamic environment for Duke. And you also say that Duke works to build genuine connections with customers by listening, anticipating their needs, and offering solution. Is that a fair restatement of your testimony at that point?
Yes, ma'am.
In the in the last Duke Carolinas rate case, there were some parties who questioned Duke's investment in Customer Connect and in AMI meters. And their position was that customers should be able to access their own very detailed data that Duke is collecting from AMI meters. I'm sorry, did that last part not come through?
Ms. Forrest, just for purposes of the record, restate the whole question, please, ma'am.
Okay. In the last Duke Carolinas rate case, there were some parties who questioned Duke's investment in Customer Connect and AMI and posited that customers should be able to access their own very detailed data that Duke is collecting from AMI meters. Are you familiar with that testimony and position that was made in the last case, Mr. Hatcher?
Are you referring to the Aretha Hunsucker testimony?
One of the testimonies from Duke was from Ms. Hunsucker. I'm sorry about the pronunciation of the name. And there was also testimony from Mr. Schneider, but also there were other witnesses, other parties who addressed that issue in their briefs, namely the EDF, the Environmental Defense Fund, and North Carolina Sustainable Energy Association, and others. Are you familiar with that?
So I'm familiar with Mrs. Hunsucker's testimony. Some of the others that you mentioned, understand that they did provide testimony in that hearing, but I personally have not reviewed.
Okay. One of the things that was posited in that case was that customers should be able to use their own already available, their own customer data through already available and used national standard protocol that's called the Green Button Collect My Data standard. Are you familiar with that?
Yes, ma'am.
So would you disagree that Green Button Collect was identified as an important feature for customers to benefit from the implementation of Customer Connect and the rollout of AMI meters?
I would agree that that was the testimony, yes.
I'd like to ask the commission to take judicial notice of its order in the sub 1146 rate case, which was the last Duke rate case. And I'd refer that it is available through AGO Exhibit 44. I don't believe it's been taken. It could be that it's already in the record, but I'm not sure.
Just for purposes of the record, Ms. Force, will you please indicate the date of the commission's order that you were referencing? And we'll take judicial notice, hearing no objection to your request. I just want to make sure you specify the date of the order.
The date of the commission's order, as I have it, it appears on page 334 of that order, and it was issued on June 22nd of 2018.
And docket number?
And the main docket number in that case was docket number E7 sub 1146.
All right.
And also, in addition to the 334 pages in the majority order, there were also dissenting opinions that appear after that.
All right. Hearing no objection, Ms. Force, to your motion, the commission will take judicial notice of its order. Thank you.
Thank you. I appreciate that. And I do not propose to put that into an exhibit, and I'm not going to rehash what appears in the order in this hearing. We can take that up in our brief. But as I understand it, the commission has indicated that it intends to take judicial notice of at least some of the issues from the other case. So I want to make sure this is available for our use. Okay. Mr. Hatcher, the commission has a pending rulemaking about access to the detailed customer data that Duke is collecting using the new AMI meters and related customer privacy issues, and that's in docket number E100 sub 161. Are you familiar with that docket?
Is that referred to as the data access docket?
That's right.
I'm familiar with that docket is taking place. I don't personally have any details as to what's being discussed in that docket.
Ms. Force, you're on mute, so you'll need to start your question over.
I'm sorry. And can you tell me, is there another witness that you'd suggest that would have more familiarity with that docket?
I would refer you to Don Snyder. What I'm aware of, Ms. Force, in terms of Green Button, is I know we're currently not part of that alliance. I do know that we do make and allow energy consumption data available to our customers if they request it. And they're free to use that data however they see fit. So if there's an app out there that they feel like they can use that data to plug into, that would give them better information on how to manage their energy usage, or whether they think they should pursue solar installations at their home, they're certainly welcome to that data, and we can and do provide that to our customers. The data access docket, I know, has taken up some of these issues, and we do look forward to the outcome of that docket. Beyond that, really the technical issues associated with Green Button, I would refer to Mr. Snyder.
And for clarification, it's my understanding that some of those issues, well, let me put it this way, that the Customer Connect works in tandem with the AMI meters. So I want to be clear that I will be able to ask my questions and get them answered if it overlaps in the Customer Connect and how that's being rolled out. Is that correct then?
It does overlap. So it's kind of one of the key components to the overall customer information system that we're putting in with Customer Connect. So the information coming off of the meters goes into the billing system, is where I pick up on in my organization. And then we also do the maintenance of those meters after they're installed. So in terms of the information that'll be coming in, it'll be coming in through our billing databases. And then, we could run queries or be able to provide that information back to the customer if requested. Also, we have a smart meter app that the customers can use to be able to extract that energy usage data pretty much on a real-time basis if they want to, enroll with that app and be able to get that information.
I do have some more.
I'm sorry, Ms. Force, I'm going to interrupt you. Mr. Hatcher, you were trailing off. We're having a hard time hearing you, particularly when you get to the end of your sentences. So if you could just be cognizant of that. We can hear you when you start your sentences, but then you trail off. So just try to moderate your volume, the volume of your voice to make sure that we hear and that everybody can hear your responses to the questions. All right, Ms. Force, I interrupted you, so you may proceed. Ms. Force, you're on mute.
I apologize. Mr. Hatcher, it looks like you're familiar with some of the issues that go to customer access to the data. And so I'd ask you to turn to AGO Exhibit 46, please.
Okay, just a moment, please.
Sure. Let me know when you're there.
Give me just a moment. We're pulling it up.
Mr. Hatcher, while you're bringing that up, I'm going to have some questions about some of the other exhibits that appear nearby there that the AGO has provided ahead of time. If you have that folder, that would be helpful.
Okay, we'll work to get that information.
Ms. Force, where are you in your cross-examination of the witness?
I have another 15 minutes or so.
Okay. So, Mr. Robinson, at this point, are we waiting to get documents in front of the witness?
Yes, ma'am.
Okay.
Chair Mitchell, if we could just have 5 minutes to just ensure Mr. Hatcher has what he needs.
All right, Mr. Robinson, I'll give you your 5 minutes, and let's also check the volume with Mr. Hatcher's system. We're having a hard time hearing him. He's trailing off, and then there's sort of a hum that also occurs when he speaks. So if you could have someone look into the system, just ensure that you all have it functioning optimally, that would be appreciated. All right,
Yeah,
let's go off the record. We'll go back on at 10:10. All right, let's go back on the record, please. All right, Mr. Hatcher, will you please confirm that you have the documents in front of you?
Yes, ma'am, I do.
All right, and I would remind you to just be cognizant of the volume level of your voice so that we can hear your complete sentences. All right, Ms. Force, you may proceed.
Thank you. Mr. Hatcher, you have what was AGO Exhibit 46 before you. That was what was pre-filed before. Do you recognize, would you agree with me that that is on Duke letterhead and it's a February 10th, 2020 filing in that docket? We were talking about the rulemaking concerning customer data that was made by Duke.
Yes, ma'am, I do.
I would ask to mark this as AGO Hatcher Cross Exhibit 1, please. I'm sorry. Can you hear me? I'd ask to mark this as AGO Hatcher Cross Exhibit 1, please, for the record.
All right, Ms. Force, the document shall be marked as AGO Hatcher Cross Exhibit number 1.
Thank you. Would you please turn to page 4, Mr. Hatcher? And I'm looking just partway down the page. There's a date shown there, and this is Duke copying in what has been proposed in a public staff proposed rule change that would be effective January 1st, 2022. And can you agree with me that Duke opposes this requirement that would say that customer data must be maintained and made available to customers and customer authorized third parties in electronic machine readable format that conforms to the NASB standard described there, or another commission approved electronic machine readable format that conforms to national recognized standards and best practices?
Chair Mitchell, if I may, the company objects. This has to do with a completely different docket. There has been no green button testimony that has been filed or pre-filed in this case. I'm not sure as to why Ms. Force is asking Mr. Hatcher these questions.
All right, Ms. Force, how do you respond?
I would explain that in the last rate case, there was quite a bit of discussion, not only about Customer Connect, but about the cost recovery for AMI meters and whether the benefits to customers are sufficient to justify cost recovery. And in this case, that question comes up again, where the company has gone forward and implemented its program without embracing some of the very important pieces of it that were put in the record last time and were to be taken up subsequently.
All right, Ms. Force and Mr. Robinson, I'm going to overrule the objection. The commission historically and typically allows open cross, but Ms. Force, I would ask that you just move through this as quickly as you can in the interest of making the most efficient use of our hearing time. Thank you.
Okay. Now, I don't remember that you answered the question, Mr. Hatcher. Would you agree that Duke opposes the proposal that has been put forward in that rule, and give some reasons for that? That's what I wanted to talk to you about. And just to elaborate, this is a green button connect type standard, in my understanding. Is that your understanding too?
So yes, Ms. Force. So I agree that what you read is in this document that I'm looking at. You know, we didn't.
Excuse me, I lost the end of that.
All right, we are having significant issues with the audio on Mr. Hatcher's setup. So here's what we're going to do. We're going to take a 15-minute recess. Duke, I'm going to ask that you provide a different setup for Mr. Hatcher and for anyone that was to testify using the audio visual setup you have in that room. So let's go off the record. We will go back on at 10:30.
Yes, Chair Mitchell.
John McCoy, are you on?
I am.
Can you hear me better?
Go ahead and talk a little bit more, please.
All right, test. Can you hear me better?
I hear you better. Keep on going.
All right, so I'll just read from the document that she gave me. So
Can you
utility shall
promote? I
maintain
think
at
it's
least
a,
24 months
I
of
actually
customer
think
data
it's
with
a device
sufficient
issue.
detail
I'm actually looking at
to
this
assist
laptop and
customers
it
in
is already
understanding their energy
exploded.
use.
So we're going to, if you could promote Allison
Did you hear
Williams.
that?
Getting there right now.
I'm hearing a couple. Is that Mo talking in the background? That sounds okay. Are you using
Yes.
a different device?
Different headset, correct.
Just pull that out so I can talk to them directly. No, I'm sorry. We have 15 minutes to get you right. John?
Yes.
Hey, we're asking, Heather is asking someone to promote Larry Hatcher. His laptop has literally exploded. The battery is no good. So what we're doing is we need to promote Allison Williams. So we'll switch out the laptops and then we'll get the volume set on hers and check that. Okay?
All right.
Thank you. Bye-bye. So just snatch it and X out.
Allison Williams, can you hear me? Allison, you there?
Were you using a mouse?
No, he doesn't use a mouse.
Okay, I'm sorry. John, can you hear me?
I can hear you.
All right, this is Allison's machine. We had Larry's, his battery has exploded. I'm sure that had something to do with the volume issue that we were having as well. So I'm gonna increase his volume to a place and I want him to speak several sentences to you in this room and see how it is. And if everybody can get out while I do that, I'd appreciate it.
Okay, John, can you hear me now?
I can't hear you.
Project.
All right, and so I'll read again, just make sure you can hear me. A utility shall maintain and at least 24 months of customer data and can you hear?
Yes.
Okay, thank you and sorry for the inconvenience.
Do you think he?
Yeah, that's no problem. Sorry, you broke up there. What was that?
I'm sorry. Do you think he needs earbuds, or are you fine with the way it is now? He's more comfortable without them.
Okay. You know, with what the problems we've had, I think we might possibly have to have headphones on. I do hear a little bit of background on there.
Excuse me, this is Joanne, the court reporter. I was listening to him reading, and it did break up a couple of times. There were a few words in there I did not hear.
Okay. Yeah. Also, Mo, are you hardline versus Wi-Fi?
He is hardline.
Okay.
Let's see.
Hey Mo, this is Bo. Can you make sure on his speaker setting it's not on automatically adjust volume? I can hear you just fine when you're speaking.
Okay. I think that may be through WebEx. I don't think so. I can't. Give me. There it is. Yep. Good call, Buck. Thank you. That's exactly what it is. And let me go upstairs and do the same thing for DeMay. Thank you.
And so, John, excuse me, you want to read again just so that.
Sure. So John, you want to try one last test?
Sure.
All right, a utility shall maintain at least 24 months of customer data in sufficient detail to assist customers. Can you hear?
Yes.
Okay, thank you.
What did you hear?
That was much better.
How did that feel?
Thank you very much.
Thank you.
Feel
John McCoy, are you there?
I am.
John, this is Stephen DeMay. I just kind of wanted to test my volume with you. Does it sound any better or?
You're coming in a lot stronger.
I am. Okay.
Yes.
Okay. Can I just keep you on for 1 second?
Sure.
I just moved the volume up a tad bit more. Is it coming through okay?
It is.
Okay. Thank you, John.
Sure. No problem.
All right. Mr. Hatcher, have we remedied the situation with your audio?
I think so, yeah.
Okay. All right, let's go back on the record, please. Ms. Force, you may proceed.
Mr. Hatcher, okay, I didn't see you back on the screen. You've moved in my windows. I'm sorry. We were talking about
Ms. Force, I'm sorry, let me interrupt you just one moment. Mr. Hatcher is now sitting behind Allison Williams' system, just so persons participating on the video conference are clear who's testifying. Mr. Hatcher is behind Allison Williams.
Yes, and Chair Mitchell, if I may, I just wanted to apologize. There was an issue with Mr. Hatcher's actual computer, so we're using Ms. Williams' computer for him to be able to testify. I hope the audio is much better on this.
All right. Thank you, Mr. Robinson. All right, Ms. Force, you may proceed.
All right, Mr. Hatcher, looking at that exhibit that we were discussing before the break, there is a rule that's set out there, and Duke has indicated about the proposal to incorporate a green button connect like standard. And I gather that one of the reasons is that even though the requirement would not kick in until January of 2022, Duke says that if the standard is required, then Duke will have difficulty implementing its Customer Connect program fully by April 2021, as is now planned. Do you agree?
Yes, ma'am, I do.
And you mentioned earlier that instead of using the green button connect, that Duke offers its customers what's called My Duke Data Download, correct?
Yes, ma'am, that's correct.
I'm having a little trouble hearing you, but I'll try to listen out.
Yep. Yes, ma'am, that is correct.
That was much better. Okay. My Duke Data Download is not a national standard, is it? Isn't that something that's Duke's own version that's based on the older technology called Green Button Download My Data?
You probably know more about that than I do from a technical perspective. You know, if I may, the reason that we were having concerns about the January date, the Customer Connect platform is really not just designed to deal with the green button issue. It's really designed, it's a whole new customer information system for our entire enterprise. So it's designed to give kind of a state of the art interaction for customers to interact with us, just like they would other large retail type customers. It's designed to be able to take advantage of the advanced meter infrastructure that's been installed in the field. So customers do have a lot more of that information available to them and they have more control. But it's also designed to give us a more personal experience with the customer versus kind of a more global experience with the customer. So all of that is really built into this tool. So it's a lot bigger than just what you're talking about with the green button. The reason we said that the date was going to be a challenge, the deployment of Customer Connect goes into DEC in April of next year. And then you're looking at a 3 to 4 month, checkout period, deployment period to make sure everything's good and we're solid. And then we're going to do DEP in November of next year. So to be able to get through that, get the project implemented across the Carolinas, that January date was of concern. And to do something with our legacy systems while we're trying to implement this new customer information system just didn't feel prudent from that perspective.
Hey, I'd ask you to please turn to AGO Exhibit 45 now.
Okay, just a moment, please.
Sure.
Okay.
Ms. Force, you're on mute.
I'm sorry, got that backwards. Mr. Hatcher, I submit that this is a response to a data request by Duke to the public staff. Do you see that? Are we on the same page?
Yes, ma'am.
All right, and I'd ask to mark this AGO Hatcher cross exhibit 2, please.
The document will be so marked. Ms. Force, you're on mute again.
I apologize. Mr. Hatcher, I submit to you that this is a description by Duke of the difference between the My Duke Data Download program and the Green Button Connect program. And it looks to me like there's a difference in functionality, that in the one case, the information would also be available automatically for approved third parties under the Green Button Connect program, but not under Duke's. At least that's one of the differences. Do you agree?
Let me read this and I'll let you know. Just a moment. Yes, ma'am, I agree.
So if we go back to the comments that Duke filed that we were looking at in that cross exhibit 1 on pages 4 through 5, would you agree with me then that Duke gives a couple of reasons for not adopting the Green Button Connect approach? One of those being that Duke has surveyed its customers and found that customer demand for that technology did not outweigh the project cost to implement it. Do you see that?
Yes, ma'am.
Clive, you agree?
Yes, ma'am.
And Duke also said that it would require commission to vet potential third-party involvement, right?
Yes, ma'am.
Okay. Taking that first reason that Duke has not found customers are interested, I'd ask you to please turn to AGO Exhibit 48.
Exhibit 48. Okay, just a moment, please.
Sure.
48.
Do you have that?
I'm getting it. Yes, ma'am.
Okay.
Okay, it's in front of me. Okay, I have it, Ms. Force.
And at the top of that, does it say on your copy, Duke Energy, Green Button Position, and Cost Benefits Analysis dated 4/12/2019?
Yes, ma'am.
Is this something that you recognize, Mr. Hatcher? I almost called you Mr. Williams. Mr. Hatcher?
I have not reviewed this, no, ma'am.
Okay. Well, first, I'd ask that this be marked as AGO Hatcher Cross Exhibit 3, please.
The document will be so marked.
And I'd submit to you, Mr. Hatcher, that this was a document that was part of a discovery response to another party in the rulemaking proceeding. And it describes Duke's survey of its customers and cost benefit analysis. If you just look at it briefly and see if you that appears to be the case to you. You can look on page 2 in particular. I'm going to have a question there.
Okay, yes, ma'am.
So on page 2, there are some projected costs of using the Green Button Connect standard, and the analysis here shows total costs for 5 years, including integration, setup, O&M, et cetera, about 1.7 million, right?
Yes, ma'am.
Okay, and then there's an analysis of how many customers might make use of their data using the green button connect standard. Do you see that?
I do.
And Duke indicates, as I understand it, that they've looked at how many users have shown an interest by looking at how many sessions have occurred where customers have gone onto the Duke portal to look at their data and taken a percentage of that. Do you agree with me there?
I believe that's correct. Yes, ma'am.
And
Chair Mitchell, I'm sorry. This is Kamal. If I may, renewing my objection, Chair Mitchell. It's one thing to evaluate the benefits of AMI and Customer Connect, but these cost analysis that Ms. Force is going into, I question whether this witness should be the one receiving these questions.
All right, Ms. Force, how do you respond?
This document is a Duke document and it speaks for itself. I'd like to just get it into evidence and we can move along. I don't have too many more questions for the witness.
All right, I'll overrule the objection and ask Ms. Force that you please move along.
I do want to ask you, this indicates a cost of 1.7 million, but putting that into perspective, it's my understanding from the last rate case that Duke has invested 73.9 million in AMI meters in 2016. Is that better asked to a different witness then?
Mr. Snyder, yes, ma'am.
Okay, I'll state that. My understanding of the investment in Customer Connect as of the last rate case was, if I have this right, 123.1 million is the North Carolina retail share. Does that sound right to you?
Give me a moment and I'll let you know.
Okay, thanks.
Can you repeat that amount, please?
In the last rate case, I saw that the North Carolina retail share of actual and estimated costs of the implementation was then 123.1 million.
I believe that is correct.
Okay, thank you. And I think we've talked about this a little bit, but you don't disagree with me that in the last rate case, there were advocates for consumers, including the public staff and in the customer data access proceeding, including the public staff and the AGO, North Carolina Sustainable Energy Association and EDF, all recommending that Duke be required to offer access using the Green Button Connect standard or some similar standard that would make it more flexible for customers to be able to use third-party applications and programs, not just Duke's. Would you disagree with that?
I would agree the way you stated it. Yes, ma'am.
Okay. I'm going to ask, and I'm not going to ask questions on that. I can do the text, but would you please look at AGO Exhibit 47? Try to make it quick.
Okay, just a moment.
Mm-hmm.
Okay.
Would you agree with me that these appear to be reply comments from Duke in that same rulemaking proceeding and they're dated July 17th, 2020?
Yes, ma'am.
All right. I'd ask that this exhibit be marked as AGO Hatcher Cross Exhibit 4, please.
All right, the document shall be show marked.
And just Mr. Hatcher, turning to page 18. Would you agree with me that the comments there say that if the commission approves the public staff's proposed rule, the companies note that they could not begin such a project until late 2022 or early 2023 after full implementation and stabilization of Customer Connect?
Yes, ma'am.
All right. So the distinction being that customers would be able to use, as you've pointed out, the programs that Duke has offered, but will not have the same options for working with third parties in order to use third-party programs through an automatic, a more flexible process that allows them to do that. That's available as a standard. Do you agree?
Well, the customer can get their data if they want to obtain their data, and they're welcome to go to any third party to use their data.
And the way it's established under the protocol that Duke has used, then if a customer does that, they would need to download the data and provide it to that third party each time they want to take a look with the application that they're using. Is that right?
Yes, ma'am, currently.
Okay. I have already talked about the commission's order in the last case. I'd ask one more thing, and that's there's a transcript that's included, and sorry, I'm trying to find the number. AGO Exhibit 30 is the transcript from the rate case,
Okay.
volume 18 in the sub 1146 case. Do you have that?
Yes, ma'am.
Pages 250 to the end address these same issues. Would you agree? Ms. Hunsaker's testimony and Mr. Schneider's from the last rate case?
Let me find the page. You said 250?
Yes. I may be mistaken. I believe that the commissioners provided a copy that has page 1 of that volume, and then it starts again on 250 to the end. Anyway. I'd ask that this volume be marked as AGO Hatcher Cross Exhibit 5.
Okay, I have it in front of me. Could you repeat your question, please?
Would you agree with me that?
All right. Let's give me an opportunity to.
I'm sorry.
Identify the document. It will be marked as AGO Hatcher Cross Examination number 5. All right, Ms. Force, proceed with your question.
Thank you. Mr. Hatcher, would you agree that this is the transcript of testimonies from witnesses Hunsaker on the Customer Connect project and costs, followed by testimony of witness Schneider on AMI meter rollout, and the last in that dated 2018 in that transcript?
Yes, ma'am.
Okay, I don't plan to take up hearing time going through the transcript, but I would ask that the transcript be admitted into evidence and available.
Ms. Force, just so I'm clear, are you moving that AGO Hatcher Cross Examination 5 be admitted into evidence?
So that the testimony in that transcript is available in this case as evidence as well. That's right.
All right, please restate your motion, Ms. Force, just for purposes of clarity in the record. I want to make sure I understand what you're asking.
Sure. I'd ask that these pages from the transcript of the testimony from witnesses Hunsaker on Customer Connect and witness Schneider on AMI meter rollout that were addressed in the last rate case be admitted in this case for use in this case.
All right, and
Chair Mitchell, if I may, the company just notes for the record that it objects, again, as I indicated before, as it pertains to this transcript being relevant to testimony in the prior case, and really has no bearing on this particular case in terms of the costs or AMI or Customer Connect investments in general.
all right, I'm going to overrule the objection, Mr. Robinson, and commission will give the evidence the weight it's due. And Ms. Force, just again, your motion that AGO Hatcher cross-examination exhibit number 5 be admitted into evidence is allowed.
Thank you. And with that, I don't have any other questions for this witness.
All right, Mr. Page, you're up.
Thank you, Madam Chairman. Technology is great when it worked. I couldn't get my mouse to point onto the camera or the auditory portion of this.
Just goes with the morning we're having so far, Mr. Page. All right, you may
It
proceed,
goes right
sir.
along with it. Is it Monday or it feels like a Monday? In any event, let me address the panel just a second. Mr. Hatcher, I'm sorry to tell you I don't have any questions for you this morning. I hope that's okay.
That's certainly fine. Thank you.
And Mr. DeMay, some of the questions that I had intended to ask you have already been covered by the Attorney General, so I'm not going to go over that again. But I do have a couple of lines of questions I wanted to ask you that I understand you have other witnesses who testify in these areas, but the questions that I have are not kind of down in the weeds type questions or very high granular questions. They're broad overview types of questions. But if I should happen to ask you something where you don't know the answer, you can just simply say, I'm sorry, I don't know. And I will accept that. Is that okay with you this morning?
Sounds good. Thank you.
All right. Would I be correct in saying, Mr. DeMay, that other than directives that come down to you from the parent corporation, Duke Energy, as president, you are pretty well where the buck stops for Duke Energy Carolinas in North and South Carolina?
Yes, I would agree with the way you worded that.
And as you discussed with Ms. Townsend, my first series of questions have to do with coal ash. So you discussed with Ms. Townsend, did you not, Duke's present engagement in what is a somewhat extensive and somewhat expensive process and program for cleaning up the remaining coal ash ponds and repositories? Is that correct?
Well, I wouldn't call it much of a discussion. We talked about the numerous lawsuits that are pending related to that matter.
All right. Then would you agree with the statement I just made that currently Duke is engaged as a result of litigation and settlements and that sort of thing in a fairly complex and expensive program to clean up those coal ash basins?
Yes, we are undertaking the kind of program you just described, but it's to comply with federal and state requirements. We are also operating under a settlement agreement with DEQ and the Southern Environmental Law Center.
And that's the 2019 settlement that you and Ms. Townsend did talk about a little bit.
Yes.
And so your settlement with DEQ, would I be correct in saying that among other things, DEQ was following the mandates of the North Carolina Coal Ash Management Act?
In what regard are you asking whether they were following?
Well, as a state regulatory agency, they've got to have statutory authority to do what they do.
They did have statutory, yes, thank you. They do have statutory authority and they have great discretion actually as the environmental regulator, both as a regulator, but also by virtue of what the statute gave them.
And that agreement, the 2019 agreement, is what is driving the timing of the cleanup of the remaining basins and to a certain extent the cost of the cleanup. Is that correct?
I would say that some of the timing, certainly, a large degree of the cost were determined by CAMA and the federal CCR rules. I would say that there were a number of coal ash basins that were previously classified as low risk that DEQ had discretion on. They exercised their discretion and issued an order on April 1st of 2019, directing the company to fully excavate all those remaining basins. And the settlement is the result of a collaborative process between the company and the DEQ and other parties to arrive at a, what I would say, a more middling position.
It was the DEQ action in requiring the cleanup of even the low-risk basins, which, if my memory serves correctly, increased the estimated cost of cleanup from somewhere in or around the $5 billion area to somewhere in or around the $8 to $9 billion area. Is that, do you recall the same thing?
Yeah, although, you know, my numbers are a little different. It took the figure to about $10 billion, their full excavation order. The settlement actually reduced that total estimated cost by about $1.5 billion. The settlement, in our opinion, brought benefits to our customers to the tune of about $1.5 billion.
Thank you for that clarification. Duke Energy Carolinas operates in both North and South Carolina, do they not?
We do.
To your knowledge, does South Carolina have any sort of statute that is functionally the equivalent of the North Carolina Coal Ash Management Act?
South Carolina is effectively conforming at this point in time with the federal CCR rules. And so we operate as one system, as you know, across borders, and the generation system is not separated by a border. It is a shared system. And so South Carolina does have coal ash remediation costs in its current rates for the North Carolina facilities. So they are covering their CCR, federal CCR costs.
In your last general rate case in South Carolina, would I be correct in saying that the South Carolina Public Service Commission stated, among other things with regard to coal ash cleanup, that it simply did not consider itself bound by the North Carolina Coal Ash Management Act?
To the extent that the Coal Ash Management Act did require a mitigation plan that resulted in a higher cost, South Carolina did say that. That's correct. We are currently appealing that.
Right. And, you know, as a result of their making that decision, they basically disallowed some of the coal ash cleanup costs that you had asked to be able to collect from South Carolina consumers. Is that correct?
That is correct. Again, the subject of ongoing challenge.
I understand that that is under appeal. Do you know whether or not there is anything approximately equivalent or similar to the North Carolina Coal Ash Management Act that impacts Duke's operations in Florida?
Are you asking if Florida has a CAMA equivalent?
Yes.
I do not believe they do.
How about the same question as to Duke's operations in Ohio?
Well, I see where you're going with this. I don't believe there is legislation like CAMA in the other states that we are operating in. That is my understanding. However, each state is dealing with compliance with the CCR rules in their own individual way.
Right. So this is really my last question on this particular point. So your answer would be the same if I were to ask you about Indiana and Kentucky.
Yes.
All right. Well, let's leave coal ash in the rearview mirror then and move on to another topic. I am correct in saying, am I not, that Duke serves a number of industrial and manufacturing customers in North Carolina?
Yes, you are.
Are those customers and their loads important to Duke's operations and finances in North Carolina?
Of course they are. In the Carolinas, the commercial and industrial sector is, or the industrial sector is about a third of our load.
Can you list any other reasons why these types of high load factor customers are important to Duke's operations? For example, don't customers like that buy an awful lot of energy from Duke and a lot of it off peak?
Well, yes, and I would say among the reasons our industrial customers are important to us is they are efficient users of power, and they are, of course, a really great source of economic development for our state, which is, has those kind of follow-on impacts for the electric utility that serves the state.
And they don't usually fail to pay their bills or pay those bills late. Would that be a true statement?
It's not 100% true, but it is generally true.
All right. And those industrial and manufacturing customers provide relatively good paying jobs, which help to support laundries and grocery stores and automobile dealership and other service industries, do they not?
They do. Duke is quite active in helping attract more industrial customers to the state.
As opposed to, say, 20 years ago, 2000, does Duke have more or fewer manufacturing and industrial customers than it did 20 years ago?
I don't know the answer in terms of numbers of customers, but I imagine our entire system has grown significantly, and I imagine the industrial load has grown significantly as well. In terms of numbers of customers, I can't say.
All right. Do you know how Duke's sales to manufacturing and industrial customers today compares to the level of such sales 20 years ago?
Not in any specific sense, no.
Were you the Duke president at the time of the last Duke general rate case about 2 years ago?
I was not.
Did you participate in that rate case?
I did, as a witness for Treasury-related issues, cost of capital, credit quality, et cetera.
Mr. Page, I apologize. I have to interrupt you. I need to inquire as to whether Commissioner Clodfelter is still on the line. I no longer see him. Commissioner Clodfelter, are you on the line?
Yes, I am. Sorry, I forgot to turn the video back on after the break, but I'm here and,
okay.
and have been here consistently since 10:30.
Okay, thank you, sir. Mr. Page, I apologize. You may proceed.
That's quite all right, Chairman Mitchell. Commissioner Clodfelter, I see that your blinds haven't gotten any younger than they were earlier this morning.
They have not.
All right. So, Mr. DeMay, again, the question for you is, do you know whether or not Duke's sales to manufacturing and industrial customers are more or less in 2020 than they were in 2000?
And my answer is, I don't have those statistics, but I would guess that it is higher than it was than it was.
Do you recall in the last rate case reading Mr. O'Donnell's testimony?
From the 2017 rate case?
Yes, sir.
I recall having read it, but I don't recall what I read.
Would you accept, subject to check, that he presented evidence showing that in the 20-year period from 2000 or 1997 to 2017, Duke had lost an awful lot of its industrial and manufacturing load? Will you accept that, subject to check?
Yes.
Have you had a chance to review Mr. O'Donnell's testimony in this case?
I did.
And he offers some evidence, does he not, tending to show that recently the trend of Duke's retail rates has been to move closer to the regional and national averages than it was, say, 5 years ago.
I will accept that he said that, if that's your question.
Yes. Do you have any reason to disagree with that conclusion?
Well, I don't know whether to agree or disagree with the conclusion. I'll agree that he said it. I don't have those specific facts available to me.
Will you agree that
I would just say sometimes when people see us increasing rates, they assume that the average is staying static, or that other companies, utility companies, are not increasing their rates, which isn't true.
All right. Did you review the tables and charts that Mr. O'Donnell included in his testimony to illustrate that point?
I reviewed Mr. O'Donnell's testimony at a cursory level, but I did look at it, and I have not committed those tables or the information you're describing to memory.
All right, sir. Will you agree that the types of customers we're talking about, the high load factor manufacturing and industrial customers, that they operate in a highly competitive environment compared to the regulatory environment in which Duke operates?
That's comparing an apple and an orange. They are in competitive businesses, and Duke Energy is a regulated utility. Two different things.
Yeah, I wasn't trying to.
But I would agree they operate in competitive environments.
Thank you, sir. Since they operate in a competitive environment, would you agree that manufacturers are always looking for ways to put their production in the areas where their costs of production are the lowest?
Well, there are a lot of reasons that go into the siting of a facility, and I think their location to their markets is one. Maybe proximity to commodities that are used in their processes and so on. I agree that their cost structure is very important, and an industry that uses a lot of electric power does look for to that index when they decide where to site.
Yeah, if I misled you with the question, I apologize. I didn't mean to imply that manufacturers base decisions solely on the cost of electricity, but that's
You didn't.
one. Okay, all right. Well, I'm glad that I didn't. Let's assume that you have a hypothetical manufacturing customer in North Carolina, which either shuts down operations in North Carolina or reduces its level of production in North Carolina. Would that have a positive or negative impact on Duke's earnings and finances?
Of course, it would have a negative impact if we lost any of our industrial load.
Right. To an extent, you can offset such a hypothetical customer's variable revenues against the variable costs that they impose. But what about the fixed costs? What happens to them if that hypothetical customer goes away or ceases production?
I didn't follow the question. Do you mind repeating it?
Don't mind a bit. Each of the industrial and manufacturing customers that you have imposes both fixed and variable costs on Duke's system. Is that correct?
All customers do.
All right, so I'm not interested here in following the variable costs. I'm interested in following the fixed costs. If a customer on whom Duke has relied through the rate setting process to pay certain fixed costs goes away, then those fixed costs don't go away, do they?
No, they don't.
And those fixed costs are ultimately going to have to find a place to land so that, in fact, they are recovered by Duke, will they not?
That's correct.
And in the hypothetical we're discussing, that landing spot could be with another customer or another class of customers. Would you agree with that?
Yes, I would.
Thank you very much, sir. That's all the questions I have.
All right, thank you, Mr. Page. Mr. Neal, you are up.
Good morning. Thank you, Chair Mitchell. No questions.
All right, Mr. Quinn, you're up.
No questions for NC Warren at this time. Thank you.
All right, Ms. Lee, on behalf of the Sierra Club.
Yes, thank you, Chair Mitchell. Good morning, Mr. DeMay and Mr. Hatcher. My name is Bridget Lee. I represent the Sierra Club in these proceedings, and all of my questions will be for Mr. DeMay.
Good morning.
Mr. DeMay, you've testified that the company took a fresh look at the viability of several of its coal-fired plants. Is that right?
At the viability of our coal plants?
Yeah, I'm looking at page 7 of your direct line 15.
All right. I see it.
Can you let me know which of the plants did the company give that fresh look?
Well, we are evaluating our fleet continuously. Witness Steve Immel, who is in this part of our company, will be taking the stand in the not too distant future. And he can definitely give you some details around which part of the fleet, measures up against what metrics. But I will tell you that we are consistently and continuously evaluating our fleet for efficiency, for economic effectiveness, and what place it plays in the portfolio, both in the near term and the long term.
Okay, so just to be clear about your testimony here, when you mention that the company has taken a fresh look, are you referring to that ongoing evaluation of the fleet, or are you referring to something else?
I'm referring to the ongoing look.
Okay, great. I have a number of questions about this. They might be better suited for witness Immel, so I'm going to go ahead and ask a couple, but you can push them to him if that'd be more appropriate.
Yeah, and I will try, and it may not be Steve in every case.
Okay. So if you could you mentioned the ongoing look, which included an evaluation of the economic viability of coal units. Could you describe that in a little bit more detail?
Probably not in the detail that you're looking for, but you may know that we recently filed on September 1st, just a couple of days ago, a new IRP for both DEC and DEP. In advance of that, we did an evaluation of our coal fleet, and we do that routinely. So it's not the first time we've ever done such a look, but we recently did or took that fresh look at the place that they serve in our generation portfolio. So I don't have details on the operational results of that review. I can tell you, though, between their economic effectiveness and efficiency as a generating source is declining. Climate policies, both at the state level and our own climate policies as a company, are also pushing this fleet to an earlier retirement than we believed even just a couple of years ago.
Thank you. So just to be crystal clear on this, the fresh look at the viability that's mentioned in your direct, there, are you also referring to the analysis that the company conducted per the Commission's 2018 IRP order calling for a more robust look at coal-fired unit economics?
you know, the words in my testimony are really just referring to an ongoing review of our portfolio. And we have taken fresh looks at that. And if we're having this conversation a year from now, we will probably have another fresh look at it. So I'm really just referring to something that's ongoing. And the state of play, the place that those assets serve in our portfolio is shifting for the reasons I described. There are economic reasons they're shifting, and there are climate and clean energy goals as reasons why they are shifting.
Okay, thanks. When the company identifies capital expenditures that it needs to conduct it at a plant, whether to comply with a regulatory requirement or just to keep an older plant up and running, how does it decide whether those capital expenditures are a reasonable choice to make?
Well, generally, we evaluate options. And the investments that we've made in our coal fleet since the last rate case are a good case study for the question you're asking. We made investments in that fleet, those investments, because we need those assets to be available to serve load. Those assets, in order to be available, have requirements, regulatory requirements placed upon them that we have to meet to be able to run them. And so we look at alternatives. Before we make an investment, we look at alternatives, and nobody has suggested that there was a lower cost alternative to replace that generation. And so we do that analysis routinely. It's just part of what we do in decision making at the company. And those investments were made because they were the least costly option for maintaining that generating capacity.
Okay, and maybe we could just talk about one plant as an example of what you've just described. I'm thinking of the Allen plant. And I believe in the company's application in this case, the company has requested recovery of costs somewhere in the ballpark of 100 million for upgrades at the Allen plant. Does that sound about right?
I'll accept that.
Okay, and would you also accept, subject to check and ballpark for sure is fine, that a large part of those costs were incurred to convert the bottom ash handling system from wet handling to dry handling? Maybe about $70 million.
Specifically in the case of Allen? Okay, I don't know that.
Okay.
Yeah, subject to check, I think that's fine.
Sure.
Again,
Okay.
I would suggest that those investments were made to keep out the Allen plant running because we needed it.
Okay. And the company is required to close units 1, 2, and 3 at the Allen plant by 2024 per a court order. Is that right?
I don't know. Steve Emmel can tell you that.
Okay. You mentioned the 2020 integrated resource plan that was filed earlier this week. I believe that indicated that the most economic retirement year for Allen units 2, 3, and 4 was 2022. Does that sound right?
I'm not sure if it's 2 and 3 or 2, 3, and 4. So I don't know. But we did move 2 units up to the end of, or to 2022. And the other units are still, I think, 2024. And
okay.
It's for really voltage support and giving us time to replace them.
Okay. And would you accept, subject to check, that on page 175 of the 2020 IRP, it was indicated that Allen units 2, 3, and 4 could be retired by 2022 without any additional transmission or any additional generation being built?
Yes.
Okay. And you mentioned the other units there, units 1 and 5. I believe the new most economic retirement year indicated in the IRP is now 2024 for those units. In prior IRPs, I think Unit 5 had a 2028 retirement date assumed. Does that sound about right?
That's right, and you have the unit numbers correct. Thank you.
Okay, of course. So is it the company's position then that the investment in upgrades that will only be utilized at Allen units 2, 3, and 4 for 5 years at most is prudent?
I'm saying that we needed those units. We continue to need those units. We did not have a less costly way of replacing that generation. And we will continue to make that kind of analysis on this fleet. I would also point out public staff who takes a great interest in the same questions you're asking has recommended no disallowance on these coal investments.
So I guess my question is maybe a little bit different. For in particular, let's talk about the conversion of bottom ash handling from wet to dry. The company undertook that in compliance with CAMA, is that correct?
I know that it took those steps in compliance with whether it's CAMA or CCR.
Okay. And is it your understanding that CAMA allows for variances of any of its deadlines?
I don't know those kind of details.
Okay.
Suggestion is we had an alternative, and I'm proposing to you that we chose the best alternatives in making the investments we made. And Steve Immel can definitely give you more details on the question you just asked.
Okay, great. And just to close out that round of questioning, and maybe this is for Mr. Immel, do you know if the company attempted to seek a variance from any of the CAMA deadlines with respect to the Allen plant?
Steve Immel.
Okay. Switching gears a little bit, in support of its application, in this case, the only direct testimony relating to coal ash cleanup activities was that of Jessica Bedarczyk, right? Is that correct?
She is our coal ash compliance witness, correct?
Okay. And Ms. Bedarsyk's direct testimony didn't present any information regarding the company's waste management policies, decision-making, or operating practices prior to 2014, did it?
How much prior to 2014? Do you mean any time prior?
Anytime.
14. If you are saying that, then I will accept that.
Okay, subject to check. I didn't see
Sure.
any mention of that in her direct.
Okay, I don't know if there is.
Okay. And Mr. DeMay, when you were speaking earlier this morning with Mr. Page, you mentioned that you had participated in the company's prior rate case. Is that right?
Yes.
Okay. So are you familiar with the testimony of John Caron in that case?
I don't. I read some of John Caron's testimony in the order itself, but I don't recall hearing his testimony a lot.
Okay. But is it right to say that you are aware that Mr. Caron was the company's primary witness for coal ash issues in that case?
Yes.
Okay. And is John Caron still the vice president of coal combustion products for the company?
I don't know.
Okay. Who might know the answer to that?
Well, I'm certain he's not, because I knew the head of coal combustion products until he moved to a different job just recently.
Okay.
So this is Larry. I can answer that. He's not currently in that role, and Jessica's in that role.
Oh, thank you so much. And Larry, if you know this better, please jump in, but the question was for Mr. DeMay, so I'll put it to him first. Does Ms. Bedarczyk have more firsthand knowledge about the company's coal ash management practices than Mr. Karen had?
I think that's a question you should ask Jessica Bedarczyk.
Okay. Does the company consider its pre-2014 actions with respect to coal ash management relevant to this application?
Not especially. And you know, the pre-2014 actions were litigated, I think, quite significantly in the last rate case. Part of the order of the commission on this matter said as much, that they dealt with issues like the management penalty. And moving forward, the question was, are your expenditures going forward prudent? And when a determination of prudency is made, that we will be able to recover our costs. So that would be my answer to that question.
Okay. And subject to check, would you agree with me that Mr. Karen's direct testimony in the prior rate case, docket E7 sub 1146, included conclusions about the company's pre-2014 actions with respect to coal ash management?
Are you going to be more specific or just?
Sure. I can. I didn't have the testimony handy for you, but subject to check, I'll just read you one line. This is page 12 of John Karen's direct, lines 14. At each step of the environmental regulatory evolution process, DE Carolinas was in line with industry standards and reasonably and prudently managed CCRs and its coal ash basins.
I remember that line.
Okay.
Your question is, I'm sorry.
Oh, so just the question is, so in the prior case, the company did put forth direct testimony regarding conclusions about the company's position on whether it had handled coal ash reasonably in the past.
Yes, because that question was relevant in that case.
Okay.
And you asked me if I thought it was relevant in this one, and I'm saying no.
Okay. So, but isn't it true that some of the rebuttal testimony in this case gets at the company's conclusions on pre-2014 coal ash management?
You asked me what the company's position is. You asked me what my position was. And my position is those issues are not as relevant in this case as they were in 2018 or 2017.
Okay. Similar question, but just to put a little bit of a finer point on it, does the company consider the history of design, construction, operation, maintenance of its coal ash ponds relevant to the question of whether the costs for which it now seeks recovery could have been lower had the company acted differently in the past?
Chair Mitchell, if I may object. That calls for a legal conclusion.
All right, Ms. Lee, what's your response?
If Mr. DeMay has he's just spoken to the company's position with respect to the relevance of conclusions. So this is along the same lines, if he's able to answer.
All right, I'll allow the question, recognizing that the witness is not an attorney.
Would you repeat the question, Ms. Lee?
Of course. Does the company consider the history of design, construction, operation, and maintenance of its coal ash ponds relevant to the question of whether the costs for which it now seeks recovery could have been lower had the company acted differently in the past?
Well, I will say, and it might even have been Mr. Karen who said it first, that it is the company's position that no decision, action, or lack of action historically on the management of our coal ash basins is causing any unjustified cost today. And so I don't know if that answers your question of relevance, but I feel like our past actions, how we got from the very first coal ash basin to the Coal Ash Management Act and CCR, were dealt with in the last rate case. And there are residual and lingering issues and things like the litigation with insurance companies and so on. But in terms of the regulatory questions that are in play in this rate case, we believe it's whether or not the expenditures we have made are prudent, whether we are effectively and responsibly closing the ash basins in compliance with state, federal, and law, but I would also say in compliance with direction from the environmental regulator. And so the question is, are we doing that, and are we doing that well? That's a legitimate question, and there may be people who think not all of our costs are legitimate. That is not our position. I would say that there is also a matter of cost recovery. That's just been evident in all of the testimony so far. But I think those are the issues at stake here.
Thank you for that answer. Mr. DeMay, would you agree with me that when the company elects to file an application requesting a rate increase, the burden of proof rests with the company alone?
Chair Mitchell, I object again. That calls for a legal conclusion as well.
I'll allow the question. We recognize Mr. DeMay is not an attorney, but I'll allow the question to stand.
The burden of proof for prudency is ours. However, if a party challenges that assertion of prudency, that party needs to establish it in no uncertain terms, in a quantifiable way, and then we must rebut that effectively in order to ultimately prevail in a prudency decision. But I think the initial burden of proof, and well, I guess ultimate burden of proof, is ours.
Okay, and for that initial burden of proof, for the evidence necessary to substantiate the company's prima facie case, you would agree with me that it's not required of either the commission or the public staff or any intervening parties to fill in the gaps of lacking evidence, and that does rest with the company.
Chair Mitchell, I'm just going to continue my objection.
Yeah, on that, I don't have an answer.
Okay.
Since legal effect.
Sure.
For purposes of the record, let me rule on Mr. Robinson's objection. I'm going to overrule it. Ms. Lee, please ask the question one more time, and I'll ask the witness to respond.
Thank you, Chair Mitchell. Mr. DeMay, would you agree with me that it is not required of, nor would it be appropriate for the commission, the public staff, or any intervening parties to fill in the gaps of any lacking evidence which may be necessary to substantiate the company's prima facie case?
I don't know the answer to your question, because if there is no such evidence, or evidence doesn't exist, or, I just don't know. I'm sorry.
Okay. No problem. I believe you mentioned earlier, perhaps when you were talking with Mr. Page, that you had read the commission's orders in the prior rate cases. Is that correct? Okay. Are you familiar with certain commissioners' dissents in those cases?
Excuse me, I didn't hear the answer on that one. Can you repeat that, Mr. DeMay?
Yes, I'm sorry. I think I was on mute. Yes was my answer.
Thank you. And are you familiar with certain commissioners' dissents in those cases, calling into question the sufficiency of the evidence introduced by the company at those hearings regarding the reasonableness and prudence of the company's coal ash expenses, or the proper rate-making treatment for those expenses?
I am aware of that, yes.
Okay. And just finally, would you consider the company's evidentiary presentation in those cases satisfactory?
Chair Mitchell, I would just ask for a continuing objection to this line of questioning, please.
And the objection's overruled. The question may stand. Mr. DeMay, you may answer.
I do think it was satisfactory and it resulted in a commission decision.
Okay. And final question, I'm just looking at your rebuttal testimony on page 5, line 14. You mentioned that it's never a good time for a rate increase. Mr. DeMay, do you think that during the middle of a global pandemic and a national recession, a rate increase is appropriate?
Well, I will answer that question in this way. I do think rate increases are hard anytime, and there are a significant number of our customers who struggle with their bills today. We only come in for a rate increase when rates no longer reflect the costs and the investments that we have incurred that benefit our customers. And we have done a lot in this rate case to mitigate the impact on our customers, especially those who are hardest hit. And we started off this rate case with our initial filing, net of EDIT, net of a return of EDIT that we had proposed at a 6% customer rate, retail average rate increase. And under the terms of the settlement, making certain assumptions around call action, et cetera, the rate increase is 2.1%. So, you know, we have done a lot of things to mitigate the impact for customers. You may have read just recently that because of a kind of an innovative approach to our fuel filing, we rolled forward the period of time for the fuel clause adjustment of DEC from year-end 2019 to the end of the first quarter. And we were able to deliver an average retail rate decrease of more than 2.1%. And so we are doing things, and I can go into the whole COVID thing of what we've done for our customers. We recognize rate increases are hard, especially for a certain segment of our customer base. But we have to reflect the investments we've made in rates, and we have to be able to achieve our targeted rate of return.
Thank you, Mr. DeMay, for your time. I have no more questions.
Thank you, Ms. Lee.
All right, Mr. Trathan, you're up.
Thank you, Chair Mitchell. Just a few. Mr. DeMay, just piggybacking on the last question, you referenced the 2.1% average proposed increase. That's an after EDIT number, correct?
It is.
And what is the average rate increase that DEC is seeking pre-EDIT?
That number is, I have that number right here. Pre-EDIT is 8.5% down from 9.2%.
Okay. And would you agree that the commission, in connection with its review of this rate case, is obligated to consider changing economic conditions, among other things?
I would agree with that, yes.
And would you agree that that would include the pandemic?
I would definitely agree with that and the economic impact of the pandemic, but I would also point out the company has also factored those very same conditions into its rate application and through its settlements.
Mr. DeMay, do you have the tech customers potential cross exhibit number 50 nearby?
Yes, I do. I have it right now.
Excellent. Chair Mitchell, if I could go ahead and identify this as DeMay tech customers cross exhibit number 1.
All right, the document shall be so marked.
Mr. DeMay, does this appear to be a transcript of a Duke Energy Corporation's earnings call from May 12, 2020?
Yes.
Did you did you listen in on this call?
Yes.
Would you turn to page 4, please? On my copy, it's the top of the page is turning to slide 7. Are you there, sir?
Yes.
Could you just look at the last full paragraph? And I would refer you to the reference to the $56 billion plan. Do you see that?
Did you say in the last paragraph on that page?
Yes, it's the next to the last sentence.
Yes.
Do you see where it says, and our 5-year $56 billion plan to invest in cleaner energy grid improvements and other infrastructures critical to customers and communities we serve will create meaningful shareholder value for many years to come. With respect to the $56 billion plan that's referenced here, do you know what that number might be for DEC?
Oops. Sorry, I pushed the wrong button. The capital plan for DEC, I don't know what the DEC equivalent over that 5-year period is. I know that North Carolina as a jurisdiction is roughly half of our jurisdictional totals. And so if I gave a number, it would be speculative, so I don't know.
Okay. And do you know whether this figure includes the proposed GIP grid investments?
It does.
Okay. That's all the questions I have for you, Mr. DeMay.
Thank you, Mr. Trathan.
All right, thank you, Mr. Trathan. Any additional cross-examination for the witness? All right, hearing none, Mr. Robinson, redirect, please, if any.
Yes, Chair Mitchell, I do have a few. So I'll start with Mr. Hatcher first, and then I'll just transition over to Mr. DeMay. So Mr. Hatcher, do you recall questions from the Attorney General's Office counsel regarding the green button standard?
Yes, sir.
And do you recall that Ms. Force in particular stated in response to my objection that her questions pertain to the prudence of the company's investments in Customer Connect and AMI?
Yes, sir.
Mr. Hatcher, are you aware of some of the benefits that AMI currently provides to customers?
I am. So the AMI technology really gives the customer a little bit more insight and control over their energy usage. So they have the ability to run reports that gives them information up to the almost minute level of their energy usage throughout the day. And then they can use that information with other apps or the third-party applications to determine if there's opportunities for them to be more efficient. In addition to that, it provides capabilities for the customer to pick their own due date for their bill. It has a capability that they can get usage alerts if they want to be able to set that up so that it will give them notification if their energy usage is getting to a certain point in a given billing cycle. There's other applications where they can, if it's a start-stop service, they can get status updates on the start-stop service based on the meter being activated or stopped. Those types of applications, yes.
Thank you, Mr. Hatcher. Are there any benefits to AMI with regards to storm response, for example?
Absolutely. In terms of storm response, gives us a better indication as to whether the electricity is still on the customer's residence. We can ping that meter and know if it's there's power at the meter or not. It also gives us the ability to better communicate with the customers on a more personal basis. So instead of kind of having a zone electrical outage and you put that information out there with a estimated time of recovery for that customer, it really gets more localized so that individual customer has a better idea of when their power being restored. Yes, sir.
Mr. Hatcher, is there anyone else in this case that can speak to additional benefits of AMI?
Mr. Snyder, yes, sir.
Thank you. Mr. Hatcher, questions with regards to the Customer Connect. Are you aware of the benefits or any of the benefits that Customer Connect will be able to provide?
Yes, sir. So, if you look at Customer Connect, we've already implemented some of those benefits. So if you look at being able to get the data loaded and being able to see how the customers are interacting with us on a routine basis. So are they interested in certain products or services? Are they having questions about their bill? Are they looking for certain information on our webpage? We can be able to see that now, so we give a more personal experience to that customer when they either interact with us digitally or call the call center for information. In addition, we talked about the AMI meters and how that interfaces with Customer Connect, so I won't repeat those benefits, but it really gives the customer a more customized experience with Duke Energy versus the way we've had to operate with our legacy systems in the past.
Thank you, Mr. Hatcher. And to speak on the synergy between Customer Connect and AMI for a brief second, is it true or are you aware of whether the foundational investments of AMI and Customer Connect are needed for innovative rate designs?
That's my understanding, yes, sir.
Thank you, Mr. Hatcher. I have some questions now for Mr. DeMay. So first off, Mr. DeMay, just for the benefit of the record, as you may not have heard Mr. Bob Page's first question, you are the North Carolina president for Duke Energy Carolinas, isn't that correct?
Yes.
Thank you. Mr. DeMay, in addition, do you recall questions from the Sierra Club and the tech customers regarding the company's rate case in the context of the current pandemic?
Yes.
And Mr. DeMay, I know you gave some of the things that the company has done when it filed its case. Do you recall, Mr. DeMay, when the company actually filed these rate cases?
The DEC rate case was filed almost a year ago, September 30th of 2019.
And thank you. And do you recall what the test year was, Mr. DeMay?
2018.
Mr. DeMay, so the majority of the costs that are included in this case, at least reflected in cost of service, when did they actually occur?
In 2018. But
which was
perhaps I didn't understand your question. I'm sorry.
No, you answered the question, Mr. DeMay. Okay. Mr. DeMay, since the company postponed its rate case, can you describe some of the additional steps the company has taken to try to mitigate the rate increase for customers?
Well, I think we, to start, we have entered into some very constructive settlement agreements. In particular, the agreement with public staff that culminated in a 9.6% ROE, a return of excess deferred income taxes over a 5-year period of time, are examples of some mitigations toward the rate increase for our customers. In the intervening time between when this rate case was filed and today, of course, we've been dealing with the COVID situation, and we have really done a lot of great things for our customers in that regard. I acknowledge that that's not part and parcel of this rate case, but it is at least an illustration of the company's ongoing efforts to help our customers when we can.
Thank you, Mr. DeMay. One other line of questions. So do you recall questions from the Sierra Club Council on the company's investments in its coal units?
I do.
Mr. DeMay, are the company's investments in its coal units, generation fleet in general, based on information available to the company at the time those decisions are made?
Well, that's when we make a decision, we're making with all the material information known to us at the time, and we evaluate all the alternatives to seeking a solution to the problem at hand.
Okay.
Yes, you know, we made the decision in the moment with the best information we had under the circumstances.
Thank you, Mr. DeMay. And in addition, as it pertains to the company's coal plant investments in this case, were many of the investments needed to maintain compliance with environmental laws such as CAMA?
They all were, they were all compliance related, or, they included the dry ash handling, wastewater and stormwater systems, lined retention ponds, et cetera. So quite a bit of required investments just to keep those plants running.
And Mr. DeMay, are our remaining coal plants currently important to serve load at this time to meet our obligations?
Well, they're critical to serving load. And in the cases, as we discussed at Allen, a couple of those units are necessary for transmission support. And so until that support can be replaced with something else, we'll need to keep those around a little longer.
Thank you. And for it, you used Allen as an example. Mr. DeMay, can you elaborate on how important Allen was during this summer's heat wave?
Well, our coal fleet isn't always the first to dispatch. I think we all know that at this point, but those plants ran a healthy amount. I don't have the specific figure, but we were running our coal fleet during the heat wave.
Thank you. No further questions.
All right, thank you, Mr. Robinson. We'll proceed to questions from commissioners. Commissioner Brown-Bland.
I don't have any questions.
All right, Commissioner Gray.
No questions.
Commissioner Clodfelter.
Yes, thank you. Mr. DeMay, I think we're still good morning. Yes, looking at the clock, good morning.
Good morning.
I have a few questions and they're a bit scattered, but I'm filling in some gaps here. I'm curious, Ms. Lee asked you about the current assignments with responsibility for coal combustion residuals, and you discussed with her the transition, I think, from Mr. Karen to Ms. Benarsic. You recall that?
I wasn't very smooth in that, but I was focusing on title tonight rather than the role.
Well, did I misunderstand the roles?
No.
No, okay. Well, thank you. I want to ask you about another name, and actually, if Mr. Hatcher knows the answer to this too, that'll be fine. In the record in the 2018 rate case, which, by the way, the commission has taken judicial notice of that record. One name that consistently appears over and over again with respect to such things as long-range planning for waste coal ash, strategic planning for waste coal ash, and identification of options for disposal of coal ash is an individual name, and apologies for the pronunciation, Isa Zarzar. Do you know that name?
So this is Larry. Yes, sir. I'm familiar with that name.
Did I get it close to being right?
Yes, sir.
Is Mr. Zarzar still employed by the company?
My understanding he is. Mr. Emmel could confirm that for you for sure.
Is he employed by Duke Carolinas or by Duke Progress?
That I do not know.
Do you know what Mr. Zarzar's current title and scope of responsibilities are?
No, sir, I do not.
Do you know when Mr. Zarzar last had assignments related to coal combustion residuals?
No, sir, I don't. Again, I think Mr. Emmel or Ms. Benarsic would probably have a better handle on that.
Thank you, sir. I'll leave you alone on that. Thank you.
All right.
Mr. DeMay, back to you. Are you still with me?
Yes.
I asked a question of Mr. Newland, and unfortunately for you, he tagged you as possibly a person who might know something about this. But I asked Mr. Newland what he knew about the regulatory agreement in Florida in 2017 with respect to Duke's Florida affiliate, whereby the commission in Florida directed or permitted, I'm not sure whether it was a direction or permission, Duke Florida to redeploy my word, not theirs, redeploy some of the EDIT in order to accomplish other objectives, cost recovery objectives. I think my understanding is they may have related to early retirement of the Crystal River plant. Are you familiar with that?
I am.
Can you just give me a more detailed description of it, put some boxes around it and give me some corners and things like that?
Yes, I can. So when tax reform occurred, or the Jobs Cut and Tax Act occurred, whenever a tax reduction occurs, our customers, all utility customers, generally benefit in two ways. One is from the lower tax rate, lowering cost of service as on an ongoing basis. The other is converting accumulated deferred income taxes into excess deferred income taxes, which at some point and in some way, customers will ultimately benefit from. The way the Florida Utilities Commission and our Duke Energy Florida utility dealt with it was actually more of a kind of an agreement. I don't know who I came up with the ideas first, but let me just give you orders of magnitude, rough orders of magnitude. The lower tax rate delivered about $130 million a year in lower tax expense for Duke Florida's customers. The excess deferred income tax benefit was about $70 million a year, and that was both protected and unprotected. And the 70 million was an ARAM flowback for the protected and a 5-year flowback for the unprotected. So you do that math, and it was about $70 million a year for quite a number of years. And what they chose to do with those funds, $200 million, 130 from the tax rate, 70 from the EDIT, was to apply $50 million of that benefit to the accelerated depreciation of Crystal River's units 4 and 5, which was a non-operating coal plant that had remaining book value on it. The $150 million was used to recover storm costs from hurricanes Irma and Michael. And they had significant balances there. I think the combination of those two was about $750 million, give or take. And that $150 million a year went to return or to recover those storm costs and replenish the utility storm reserve, which I think, this one I can't remember, but it's about $125 million. So that's how they did that. And let me just add that the storm flowback or recovery piece will end in mid-2022. The accelerated depreciation component will continue until their next general rate case, at which time it will be revisited through depreciation studies and in the ordinary course. And that rate case, I think, is a 22 rate case.
Thank you for that. What I'm curious about is, in the absence of that agreement with the regulators, would I be correct to think that Duke Florida would have been seeking to recoup those costs, the excess book value and the storm costs, by seeking recovery through rates?
Well, I do know that Florida has a storm securitization law. So I don't know whether
I apologize for interrupting you. Let me focus really on just the piece then that related to the Crystal River early retirement and the depreciation that was still on the books that needed to be taken. Am I correct that the company, if it hadn't reached that agreement with the use of the EDIT, would have instead been asking to recover that book value in rates?
Yes, but they are effectively recovering it in rates still. And they're, so the accelerated depreciation, I mean, it's a netting of sorts. It's these revenues expenses are fungible. So they could have given the customer the benefit of the EDIT and then increased rates for the accelerated depreciation. This was an opportunity for the state to achieve two policy really priorities. One was an interest in accelerating the depreciation of their coal fleet, and also to pay for the destructive storm damage. And tax reform allowed them to do it without affecting customer rates.
Thank you for that explanation. And I understand the netting concept. That's exactly what I was really focused on. You can probably guess my interest in the subject. We'll leave it at that for now. Let me move to a different topic.
Sure.
On pages 9 and 10 of your direct testimony, you discuss some ideas the company has investigated. You don't need to have this in front of you, but if you want to get it, I'll give you a moment.
No, I haven't.
Okay, great. You discussed some of the ideas the company's been exploring to bring forward programs that might be of assistance to lower income customers. And I appreciate that testimony, and I thank you for that testimony. I'm just curious about why the company chose not to bring any of those forward to the commission in this rate case for consideration and evaluation and possible either piloting or for implementation. Why not bring them forward in this rate case to at least for a good look see?
Well, I have an answer for that, and the answer is this. We have learned, and sometimes the hard way, that to do really hard, complicated things requires a thoughtful, deliberate, and robust stakeholder process. The numbers of stakeholders that are interested in anything that we do is, as you can just imagine, is great. When you start thinking about low-income programs and the like, whatever does spring from that effort, other customers are going to have to carry. And we thought that what this process needed, that Power Forward didn't do, and that frankly, Commissioner Clodfelter, Senate Bill 559 didn't do enough of, was stakeholder support. We didn't build it in those efforts, and we were effectively unsuccessful, at least in the multi-year rate plan part and in Power Forward, because our stakeholders want to be involved in those kinds of major decisions. And so the whole idea of the collaborative around low income was for the commission to put their imprimatur on this effort. Because I think everybody thinks this is important. You asked a question the other day, why now? And why didn't it happen earlier? And there's not a good answer for that, but it doesn't mean because Duke didn't give a second thought to its customers who are struggling. And it's not because public staff didn't or the commission didn't. We just didn't, just like why is the country just now wrestling with systemic racism and social injustice? Sometimes you just have to get there. And I am suggesting that the company is serious about its interest in doing structural changes to benefit our low-income customers. We are very, we are very generous in our contributions to things like Share the Warmth, the Energy Neighbor Fund, the Helping Home Fund. I have statistics about all the millions of dollars we've given to those programs over time. But I think now is the time to think about structural change to rate making and rate design and just those kinds of things to help our customers in a much more structural, enduring, lasting way.
I want to say that I really appreciate the seriousness and the sincerity of your answer to my question. I appreciate it. And it takes me to what may be my final question, really, because I believe what you said. I agree with what you said about the time being right and the time being now. And so I need from you some comfort on one point. So I'm being asked to have confidence that this stakeholder process that's being proposed, have confidence in that process going forward. And where I struggle a bit is I then look at the fact that the company has, through various settlements, partial settlement agreements, has made certain commitments to support a particular proposal or to oppose a particular proposal or not to put forward a certain proposal. All of those actually really deal with cost of service, but as we all know, cost of service issues often are strong drivers of what happens in rates. And so I look at those and say, the company's tying its hands already in these settlements. What am I to do with that in terms of the integrity and the confidence level I have in the stakeholder process? I don't know if you want to respond to that question. It may just be that I should leave it out there rhetorically.
I'd like to, if I can. So, first of all, we believe our settlement agreements are constructive, and we support them. We were careful, I guess, in coming to some of the terms of those settlement agreements to leave open and preserve the true potential of this collaborative. The fact is, a number of the parties that we entered into these agreements on will be important parties at that collaborative table. So whether they brought those ideas to us in the form of a settlement, or whether they brought them to us at this collaborative table, I think all these ideas are worth exploring. It was just a number of days ago when there were a lot of discussion around this, and you could hear a different sound out of the industrial group, and you could hear a different sound out of the low-income advocates. And so you can only imagine how challenging this will be, which is why we came to the commission. If we had just been silent about this and decided to roll out a stakeholder process ourselves, I think a number of parties would have looked at it like they look at anything our company does, with a jaundiced eye, which is unfair, but it's a fact. And but like I said, putting the commission seal of approval on this with expectations. And I hope that I am part of delivering back to the commission something that exceeds your expectations, but more importantly, does something positive and lasting to solve an issue that has been around way too long.
Again, that's helpful. Thank you. And let me ask you my final question, really. Recognizing the pressure that the company is under, and for that matter, the commission as well, from various interest groups, each of whom has their own special view about how things should work to their advantage. What would the company think if, and I have not vetted this with any of my colleagues, this is just me speaking as one commissioner, but what would the company think if the commission were to suggest or propose perhaps that the process could be assisted if we had a third party involved as well, some independent expertise to assist in making sure that no voice got to be the overriding dominant voice in the discussions? Would the company think that that was helpful?
I commit to you now, the company would support that proposal. And I can tell you from my own personal experience that the stakeholder processes that have gone the best that we've been involved in have all been professionally mediated and structured and run by people who do that kind of thing. You look at the Clean Energy Plan process. You look at our own grid improvement plan process. You know, Jay Oliver spoke a lot about what we did leading up to this proposal. We did a lot, but we didn't do it by ourselves. And I think it would have been harder to.
Mr. May, I appreciate your time this morning. Thank you.
Thank you, Commissioner.
All right, Commissioner Duffley.
That's all I have.
Commissioner Duffley.
Yes, I have a few questions. Good afternoon, gentlemen. Most of my questions will be, or all of my questions will be for Mr. DeMay. So you've testified about many factors that is causing upward pressure on rates. You have coal ash expenditures, grid modernization, costs to meet your carbon reduction goals. And you also attended the public witness hearings and have committed to this stakeholder process to discuss the issue of affordability. And I think that I heard probably some of the answer to my question, but I just want to make sure if you have anything to add to this question. Has the company thought about, or is the company concerned about rate case fatigue? And what is the company actively doing to address that concern?
Yeah, you know, I will just say something that I think anybody involved in this process already knows. Rate cases are really hard. They're very costly. They just sap organizations of resources. And, you know, I think rate case fatigue is a real issue. We made, or let me say it this way, we supported legislation in 2019 that would have provided multi-year rate planning. And one of the virtues of multi-year rate planning is the ability to put programs and certain kind of identifiable and observable plans and expenditures and so on the table, do a little bit of the hard work of vetting it, and then letting it go for a while. And, you know, there's been a great deal of resistance to that idea here in North Carolina. I chalk up at least 50% of that resistance to the way we rolled it out. But I can just tell you, though, that we are supportive of mechanisms that diminish the need for frequent rate activity. But I also want to add, though, that the level of investments that are required to improve, to maintain, and to expand our infrastructure are not decreasing. And so there has to be some ability to bring these investments into rates in an easier fashion and in perhaps a more moderated fashion over time. And so we continue to explore ideas that would get us to that kind of place. So I don't have the solution for you. If it's worth anything to you, we agree with your view on how hard these rate cases are. We have responded to 8,000 data requests in this rate case. We have 29 witnesses. Even with settlement agreements with 10 different parties, every issue is being litigated by somebody. And, you know, I think some reform would be great. I just haven't cracked that nut yet.
Okay, thank you. And I'd like to give a caveat to the next set of questions that I'm about to ask you. No one should read anything into these questions, or if I'm leaning one way or the other. I'm just trying to obtain additional data points. And really, as a new commissioner, have some education on the issues that I'm about to ask you about. So in the last rate case in E7 sub 1146, DEC put forth 2 proposals to the commission in an effort to assist with cash flow and credit metrics. The first is what I call the run rate. Other commissioners call it something different, but it was to add approximately 200 million to the revenue requirement in that case. And then the second proposal was to increase the revenue requirement by 200 million as a cash flow mitigation measure in response to the company's requirement to flow back the EDIT. So it was a total of 400 million. Did I generally capture DEC's proposal in the last rate case?
Yeah, I wasn't sure about the EDIT number, but I totally accept your version of that.
Okay, thank you. And in the last rate case, in your post-hearing brief, and that was filed in April of 2018, and specifically on page 42, the company suggested that although the written proposal in DeMay Rebuttal Exhibit 5 did not identify specific use of the $200 million relating to the cash flow mitigation measure, the brief suggested that the EDIT flow back and the coal ash costs, I think it was in that case, the ongoing coal ash costs could offset each other. Did I accurately summarize the portion of DEC's post-hearing brief?
Yes.
Okay. And I am aware of the testimony by both DEC and the public staff regarding their respective positions on the return of the unprotected federal EDIT, totaling approximately $982 million. So I'm aware that the parties had different positions, right? But in the end, in the second agreement and stipulation of partial settlement, you and the public staff have agreed to flow back the unprotected federal EDIT over a 5-year amortization period with a return. Do I have that correct?
You do.
Okay. And the deferred coal ash costs through January of 2020, in this case, is approximately 491 million. The commission has not yet received the audited revenue requirement reconciliation from the public staff, but I'm assuming that those numbers have been updated through May of 2020 or not.
Coal ash has only been updated through the end of January for DEC.
Okay, thank you for that. And so it's, and DEC's position related to the deferred coal ash case through January of 2020 is to recover the cost over a 5-year amortization period with a return. Am I correct in that DEC position?
You are correct.
So both the unprotected federal EDIT and the deferred coal ash expenditures have a 5-year amortization period under what you're currently presenting to the commission. Is that accurate with the settlement agreement with public staff?
That is a true statement, yes.
So again, so I'm finally getting to my question that I did caveat earlier. So did the company think about requesting in this case what it requested in the post-hearing brief in the last case about doing a full offset of the deferred coal ash expenditures with the unprotected federal EDIT within the context of this rate case? I mean, I just need a little education why, if there's some type of benefit to extending it over 5 years, if it has to do with the revenue requirement. Could you speak to me a little bit about that issue?
Yeah, I think our experience back in 2018, where we made that proposal, and for very good reasons, the commission said, let's deal with this in the next rate case. As I remember, we were compressed on time from when the hearings were held to when the Tax Act became law to when We had to deal with the rate reduction, and to get an order out, it just seemed like that was a complicated way to resolve EDIT. And, but to answer your question, did we consider doing that in this case? Yes, because we think about all kinds of scenarios, but we chose to do it just to keep the parts separate. In part because the impact to customer bills are is kind of the same, whether you just offset them or whether you are, letting each one kind of amortize over a different period. I guess what I'm trying to say is that we knew EDIT was a powerful rate mitigation tool for our customers. I mentioned before that it's taking our original ask of net 6% down to net 2.1%. That's the power of such a large EDIT balance. The knowing, however, that EDIT, we thought EDIT should be, well, let me say that there's a school of thought that says EDIT should flow back at a different rate than 5 years, that it should flow like ARAM does. But we knew it to be also a tool and a lever, and came to a very constructive settlement with public staff on that. And so maybe I didn't answer the question directly, but we considered it. We just didn't choose to apply for a rate adjustment that way.
Okay, thank you for that. And
I could have gotten to a lot more quickly. I'm sorry.
Well, it took me a while to get to my initial questions, so we're even there. But I did read your testimony, and part of your initial testimony was with respect to the EDIT, the sense of gradualism, and I'm just wondering, I mean, whether you handled it the way you have with the public staff settlement versus doing a full offset in this case. I mean, if either way would not necessarily be addressing the tax issue in a haphazard manner, in your opinion, or do you have concerns that there could somehow be rate volatility and harm to the customers or to the utility?
I'm going to rely on my colleague Jane McManus to clean up the answer I'm about to give you. So if you are flowing back EDIT over a 5-year period and proposing to collect a like number on coal ash expenditures, for instance, over that same 5-year period, there is no difference between that and just netting the two. In fact, in a way, that's kind of what you're doing. I believe what Florida did was outside of a general rate case. So what the situation we have here is we have a general rate case with dozens and dozens of moving pieces. We would love to collect our coal ash expenditures over a 5-year period of time. Steve Young was very clear about the importance of cash flow generation to the company. We support the settlement of the 5-year flow back of EDIT to customers. I think in a general rate case, the commission has the ability to change periods and arrive at a targeted outcome, if you will. And so I think that's kind of the beauty of doing these things in a general rate case. And I don't know if that was responsive to your question, but I am just not seeing the difference between dealing with all these issues at the same time in the same general rate case. I just think it's all happening. This netting is happening.
Okay, thank you for that. And so now I'm going to get to my additional data point that I would like to see. And if I could have a late filed exhibit on this, what I'd like to see is a revenue requirement reconciliation, like a Boswell Exhibit 1. And Mrs. Downey, it might be more appropriate for public staff to do this, but I'm going to ask Mr. DeMay. And it sets forth this hypothetical where the total amount of the deferred coal ash expenditures is fully offset by a portion of the unprotected federal EDIT. So that I can see any type of revenue requirement impacts and the effects to the EDIT rider that the public staff and the company have agreed to in their second stipulation of partial settlement. But which one of you would like to volunteer for that late filed exhibit?
Commissioner Duffley, if I may, Chair Mitchell, respond to that.
You may, Ms. Downey.
Commissioner Duffley, Ms. Boswell will be filing full sets of schedules with our update testimony, assuming the commission allows us to file it on September the 8th, and we would be glad to include such a reconciliation at that time, if that would be okay.
That is acceptable to me. Thank you very much, Ms. Downey. And I have no further questions.
Thank you, Commissioner.
Thank you.
All right, Commissioner Hughes.
No questions at this time. Thank you.
Okay. And Commissioner McKissick.
Thank you, Madam Chair. I do have a couple of questions, and I guess first I'd like to address them to Mr. DeMay, and it's going to touch upon some of the concerns that Commissioner Clodfelter spoke of when he was discussing the policies that could be implemented to impact affordability and issues of that sort. I remember reading back in your, I think it was your direct testimony about programs such as a low-income bill credit that would apply to your basic facility charges, and as well as looking at expansion and retooling of the supplemental security income. Are those types of initiatives already taking place outside of North Carolina, where Duke operates today?
I don't know the answer to that question. I don't know what low-income assistance measures are in the rate structures of the other states we do business in. I'm sorry.
Okay, but you are committed to working diligently to try to see what we can do to facilitate the consideration of various programs as expeditiously as possible, rather than, and I know you talked about pulling together groups of stakeholders to work through things, but what is it that you're able to commit to today, so that I understand that?
Well, we would like to undertake this collaborative with public staff over the course of a period of about a year, and provide frequent updates to the commission as to our progress, and all along the way give the commission an indication of where things look promising, where we're hitting roadblocks with stakeholders, et cetera. We propose this collaborative in a very thoughtful, serious way, Commissioner McKissick. And by bringing it to the commission for its seal of approval and its imprimatur, if we wanted to just be all showy about it and not real substance, we wouldn't have done that. And so we want all stakeholders' feet to be held to the fire on this.
Okay. And
all right, Commissioner McKissick, I apologize. I've got to interrupt you. We've come to our lunch break. So
Okay.
we will go off the record now. We will go back on at 1:30 and we will resume with questions from Commissioner McKissick.
Hey, John, is it working?
Yeah, I hear your audio is great.
Oh, yay. I had to find some internal settings on my computer, but it was just driving me nuts because the internal test would work, and then when I tried to check in with you, it didn't. So I'm thrilled it's working. One more question. So
sure.
I expect that I'll be doing cross-exam tomorrow.
Okay.
During that cross-exam, do I need to hold my space bar the whole time, or can I unmute myself for a long period of time?
Sure. Here's the deal. So like, go ahead and put yourself on mute. And then when you want to talk, you just push down on the space bar and hold it.
Okay, but I need to hold it the whole time while I'm doing cross-exam.
No. While you're talking. And then once you let go of it, it goes back to mute. So you put, basically it's all it is push to talk. And so it's just basically, it's good for Q&A. So it's just an option of whether you want to do that or not, or you want to manually mute yourself. It's just a new WebEx feature that just occurred maybe last week.
Okay, very good. Well, thank you so much for checking in with me. I feel much more confident about tomorrow now. Thank you.
Sure. We can also try, I mean, I know you had like earbuds. I mean, if you want to throw in your earbuds and try that, you can too if you want.
Well, that's what I've got. Well, I've got the AirPods in now, and they're working fine.
Okay, great.
And I'd actually just stolen somebody else's earbuds this morning in a panic. But if I can make these work, then I'm much happier.
Okay, yeah, I couldn't see that you had them on. Okay, I didn't know you had wireless.
Yeah.
No, you sound good. Again, if you want to test early, like I told you, I'll be on at 45 minutes before tomorrow.
All right.
And if you need to do it, I have no problem with that.
Okay, thank you so much. I appreciate it.
No problem.
All right, take care. Bye-bye.
Go ahead, Tim.
Hey, John, can you hear me all right?
Yes, can you turn on your video, please?
I'm getting a message from Cisco WebEx that says they're not able to detect my webcam. Let me see what I can do here.
Okay.
Showing up now, John?
Yes, sir. Yep. You, yeah, video's working. Audio sounds good.
Okay, thank you very much. Appreciate it.
Sure, no problem.
All right, it is 1:30. We will get started momentarily. Just to give you all a preview, my plan is to go until about 3, at which point we'll take a break for our court reporter. And then we will conclude the day at 4:30. And we will start back up tomorrow morning at 8:30. We will go on the record in the morning at 8:30. We will have a shorter day tomorrow. We will end by 1 o'clock tomorrow. All right, let's go back on the record, please. And we are with Commissioner McKissick and his questions for the Duke witnesses.
Chair Mitchell, before we get started, if I may be recognized, Diana Downey.
You may, Ms. Downey.
Chair Mitchell, during the break, and I'm hearing a lot of echo, I'm sorry.
Commissioner McKissick, you may need to, okay. All right, proceed, Ms. Downey.
My apologies, but during the break, my accountants rightfully pointed out to me that I overpromised, at least based on what I heard during the proceeding earlier, and that there are that we need additional guidance as to some of the parameters around the document and the schedule that Commissioner Duffley asked. But rather than take up hearing time at this time to ask for clarification, if it's okay with the chair, we would like to file a letter asking for that guidance, and we'll respond accordingly.
All right, Ms. Downey, that sounds like a good approach. Commissioner Duffley, as long as that approach works for you.
That does work for me, or we could just have, if it's acceptable to all of the parties, you could call commission staff, the legal staff working on the case. And either way.
Whatever your preference, just let us know.
I'll leave it to you, Chair Mitchell.
All right, Ms. Downey, why don't you just file your request in the docket, and we will respond accordingly.
Thank you, Chair Mitchell.
All right, thank you. All right, any additional administrative or housekeeping matters to attend to before we resume with Commissioner McKissick? All right, hearing none. Commissioner McKissick, it's with you.
Thank you, Madam Chair. I guess I was asking a few questions of Mr. LeMay, so I'll continue with those. Of course, Mr. Hatcher, at any point you want to chime in, certainly feel free to do so. I know, Mr. LeMay, when Commissioner Duffley was discussing the idea of rate fatigue, one of the things you brought up was, multi-year rate-making authority. I did not know if at this point in time it was the intention of either Duke Carolinas or the Duke entities, I should really say, because I think they should both think about it as a potential to pull together stakeholders to work through the issues and challenges that multi-year rate making presents that may clarify and provide answers to some of the concerns that were raised last year when this was considered.
Mr. DeMay, would you unmute, please?
Sorry about that. I mentioned multi-year rate planning as an illustration of a way to address rate case fatigue. There are many ways to do so. You asked, are we considering ways of addressing or exploring the opportunity with stakeholders? And I am pleased to say that the clean energy plan process that is underway right now has two very important tracks associated with it. One is a climate policy track, and the other is a regulatory mechanisms track, where the group, and it's a large group of stakeholders, but all the important stakeholders are at the table. We are evaluating decoupling, things like decoupling, multi-year rate plans, performance-based rate making, and the like. So I'm very happy to say that a lot of work is going on in that space right now. So while I mentioned it as an example, and I also mentioned it as an example of the importance of the right inclusion and the way to roll things out and so on, we are in a much different place and in a much better process right now. You're on mute.
What is the timeline for that for that group to try to reach some sort of consensus as opposed to this being relatively open-ended?
Well, it's definitely, while it may technically be open-ended, the regulatory mechanisms part, I can't imagine it's going to go on much beyond, say, the early part of next year for two reasons. One is the first track, the climate policy track, owes the governor a report by the end of the year. We expect that that report will not just address climate policy issues, it will include a discussion of regulatory mechanisms that will help the state achieve its climate objectives. But I think importantly, this group of stakeholders is not one to sit on this discussion for long. There's going to be no dilly-dallying, I can promise you. And I expect that the report to the governor at the end of the year will include some recommendations to explore further those mechanisms.
And one other issue that has emerged, in the last year or so, I mean, there was authority given for securitization for storm-related costs and expenses. Has there been a thought given to expanding securitization for other areas that might be appropriate outside of just storm-related costs?
Yes, yes. I would say of securitization, as the former treasurer of the company, and I actually led the securitization transaction for our Crystal River 3 nuclear plant in Florida. It is an extremely complex tool, but it is an extremely effective one. But it has limited utility, I should say. The company cannot, first of all, it has to get new legislation. Secondly, a company can only avail itself of so much securitization because securitization is a binding imposition of a cost on customers. Nothing can change it. No commission can change it. Really, the legislature can't even change it. And so once it's set, it's a binding commitment. And if you just start piling up these binding commitments, it takes flexibility away from the commission, for instance, to do things in a more creative sense, expanding amortization periods and the like. And so securitization has that limitation. Securitization also has the limitation, though, of eliminating the return that investors were getting on their capital. It is true that a securitization returns that capital instantly, the unamortized capital back to the investor or back to the company. But the ability to redeploy those kinds of proceeds is not always an easy thing to do. So securitization comes with some complexities. It is a tool that has been used for storms. It has been used for stranded assets, but not a great deal more than that. And I see the opportunity to use that tool again in our future. But I wouldn't say, oh, and I would add, I'm sorry, that securitization is also a topic of discussion at the Clean Energy Plan table.
Another area of concern, I know that we have before us a plan for grid improvements that are looking at like $2.3 billion or so over the next 3 years, which is pretty strong, pretty aggressive program. I know when Witness Oliver testified, I raised questions with him about, if engineering would be done in-house or using outside services. He mentioned there would likely be both. I asked him about the way work would be performed, whether it's your internal crews or whether you're bidding out some of this work. We did not get into whether it would be public bidding or private bidding. And when I say public, advertising it for people to submit bids, or whether it would be private where you went back to people you have utilized in the past and just got competitive offers from different companies or providers of services. But the thing that I did not hear anybody speak of is the extent to which, with such a substantial amount of money being spent in that area, potentially, the utilization of what I would call firms that have been historically unutilized, disadvantaged businesses as they might have once been known, and are breaking it into segments so that small businesses, regardless of their makeup, have a greater opportunity to get a portion of that work, particularly at a day and time where our economy is being hurt and small businesses in particular. Can you share with me your thought on what plans Duke has at this time to really try to reach out and provide contracting opportunities to competent and qualified small businesses and historically unutilized businesses, providing this moves forward as it is proposed at this time?
Yes, absolutely. I can speak in a general sense about our supply chain objectives. I can't speak specifically to the grid improvement plan, but I think of what I'm about to say to you encompasses the grid improvement plan. Back in June, the company announced that it was launching Higher NC, which is a commission kind of directed program. And that is something that we are very enthusiastic about, very excited about. It will push more of our supply chain spending to local companies, North Carolina companies, and diverse companies, women-owned companies, veteran-owned companies, minority-owned companies, and so on. And we are, kind of the nature of the program is that for investments greater than, I think it's $700 million, we are, it's kind of, it's one of the protocols of the program is to include those kinds of firms in that work. So we're really excited about that. But I also wanted to mention too that it's not, we didn't just start using those firms under the Higher NC program. For the past 5 years, we have averaged $1 billion spent with the kind of firms you're describing. And in fact, in 2019, it was kind of a high watermark. $1.6 billion was spent with those firms. So I am pleased to say that I actually think we're ahead of the curve on this. And I would expect that segments of our grid improvement plan will be part of the Higher NC initiative.
Thank you for that explanation and putting things in context. I know I have read and heard about what some other utilities are doing that are comparable to Duke. I had not read or heard as much about what Duke has done. But I think that to the extent to which significant efforts and substantial efforts could be made to continue to promote and enhance those opportunities, I think it would be for the greater good of the economy and for helping to build opportunities for those who've not had a chance to participate traditionally in that American economic mainstream. Now, I guess the other questions I have, I guess, really perhaps are more appropriate for Mr. Hatcher. So, Mr. Hatcher, I guess in reviewing your direct testimony and in reviewing your rebuttal testimony, you spoke about a CX monitoring program and how it was developing data and analytics to improve delivery of service to customers. So I'm wanting to know, what information have you actually obtained, and how has that data and that information of analytics been utilized to improve services? And is there any measurable index that you are using to measure success as a result of those programs or initiatives you've undertaken?
Yes, sir. So the CX Monitor tool is a proprietary survey that we developed in-house back in 2018. And the reason we did that, we were looking at J.D. Powers as an indicator but it's really an indicator of how we perform against other utilities. And you don't get a lot of internal written feedback on why people score you the way they score you. So the CX Monitor survey was created so you could really see how customers perceive Duke Energy. Would they recommend Duke Energy to their friends and family, or would they not? And kind of what is the reason why? And there is an index to that. It's an MPS score that we track internally. And we're kind of tracking that to see if we're improving on the areas that are raised as concern or if we're lagging. In addition to that, we created a Fast Track 2.0 proprietary survey, which is more of a transactional based survey. So if we have one of our technicians go to a customer's home, perform a service, we can get immediate feedback off of that transaction. And it also gives us verbatims so we can understand how the customer, why they rated us the way they rated us. Another component of that is called a reflect survey, and we're doing the same types of feedback from our digital services and our call center services. So we can take all of that data along with our customer complaint data, and we can really see the things that are frustrating customers, as they move along their journey with us. Some of the things that we've done with that, if you really look at the top three things, it's around billing and payment. So folks wanted their bills simplified so they can understand it better. They wanted more information and more control. So if you look at what we're doing with AMI and the information that's being provided to the customer, we're meeting that need from that perspective. If you look at the other options AMI is giving the customer around pick your own due date, start stop service, making things easier for the customer. We're seeing positive feedback there. They want more flexible payment arrangements. So if you look at that, what we've done with our COVID response, a lot of the feedback that we received from customers, we applied in our COVID response. The other area that we heard loud and clear from our customers is they want us to communicate better with them, especially around outages. How long are we going to be without power? When's my power going to be back on? Not necessarily my neighbors. So AMI has helped us in that space. The tool itself has helped us in that because we can communicate more directly with the individual customer. We can send them pictures of the damage. We can show them where it's located. We can send them another picture where the crews arrived. So it keeps them updated along the way, so they're not just sitting there wondering what's going on. And then the last piece of that is really around the outage experience. And what our customers are telling us is that they recognize we're going to have outages due to the major storms, but they want us to recognize that and figure out ways to minimize those impacts and really get faster on the response and restoration. So hence what you're hearing in the testimony of Mr. Oliver is addressing a lot of that.
Now, it sounds as if, as you said, it was a proprietary system. You've used it in-house and it's helped a great deal. Do you ever use outside firms or consulting firms that might help in doing similar type of analysis and comparative analysis, comparing what your performance is as Duke compared to other comparable utilities, to try to get some sense as to where you are in terms of a national performance, if you can speak to that?
Sure. So JD Powers is our major source of data in terms of how we're performing against our industry peers across the country. We also do consortiums with like my peers where we talk about what's working for them and what's working for us, and we share ideas back and forth. And periodically we'll do benchmarking with another utility that we hear is doing something really well. We'll go visit them to learn about what they're doing and vice versa. So yes.
Point to any things that you've learned from that, or any enhancements or changes that you've made?
So one of them is the fee-free credit and debit card program that is, and as part of this rate case.
Right.
We've gotten a lot of feedback from our customers that they want this. They're very frustrated that they have to pay a fee. And we've also gotten the same feedback when we did benchmarking with some of the other utilities. So hence, we're bringing that one forward, to eliminate the customer concern. That would be one example.
In your testimony, you also referred to something known as the PINGIT program and
Yes,
what that constituted, as well as discussing additional efforts you were utilizing to communicate with customers using social media. So can you address those two issues?
Sure. So PINGIT is a part of the AMI technology that we can actually send a signal from our control center to that meter to determine if that meter's active and is powered up and there's power at the home or not. So it's a quick way for us to be able to determine the status of a customer's electricity, so to speak. So it's really a new improved technology versus our old meter sets that used to be in the homes, where you'd have to roll a truck just to determine, if the meter was operational or not operational. In terms of some of what we're doing in social media and other ways to communicate with customers, we have drastically improved our website. We've done kind of a web refresh starting back, I believe it was in 2015. We've had quite a few updates to that over the years. We're being able to give customers a lot more self-serve options, so they don't necessarily have to call the call center to be able to start or stop service. They don't have to call this call center to make a payment. They can do all that online. There's other services that they can go out there and self-serve versus having to wait on the phone to be able to talk to an agent. We're using social media a lot with our customers that we have email accounts for or phone numbers to be able to send them information. So if we need to send them a notice about a proactive outage that we're taking for some reason, we can do that in advance so they're aware of that. If we need to send them information related to a potential bill change, we can do that in advance so it's not a surprise. Those types of things where we're able to communicate with our customers again, kind of more individually and more directly than we have been in the past.
And I guess my last question deals with sustainability and in terms of, I guess, what I know in your testimony you talk about what I call corporate sustainability goals for sustainability that are being pursued, that are being implemented, and initiatives that are being undertaken to obtain them. Can you speak to those in a more discreet way?
I will give a shot at it. Before I do that, you asked for some tangible results.
Yeah.
Our scores. I'll give you a little bit of that out of our fast track surveys. If you just look at DEC alone for start-stop service, 86% of our customers are satisfied with their experience with us for start-stop service. If you look at our outage restoration, 81% of our customers have been satisfied with how we've responded to outages. And then street light repair is another key area that we've gotten a lot of feedback on. 73% of our customers are satisfied with their experience for street light repair. So maybe that'll give you a little bit of tangible data to have some context around those surveys. And in terms of sustainability, the company, I'm really proud of what the company's doing in terms of our sustainability goals and how those goals are in alignment with what you're seeing out of climate change. And if you look at really goal 7 and goal 13 of the climate accord, we're really in alignment with those goals. So it's around affordable and clean energy, as well as protecting the planet and climate action. So if you think about just what we've done over the last several years since 2005, a 39% reduction in carbon emissions by the way we're managing our fleet. You think about our solar development with the second largest solar capacity in the country behind California. We look at what we're doing in terms of battery storage and the plans for battery storage going forward over the next 15 years, about 375 megawatts of battery storage. And then with our plan to be at 50% carbon reduction by 2030. I think it just speaks to a lot of what Stephen has talked about and what's in our IRP and what we've been doing to really improve our sustainability going forward.
Well, thank you for those responses, and I hope as we move forward with the IRP that we will really work in a very concrete way to move toward the sustainability goals. And I guess the last thing, and perhaps neither of you are the best witness to speak to it, but how would, say, accelerated depreciation of the coal-fired generating plants help us get closer to that? And if we did not have it, what would the impact be?
So I'll take a stab at that. So we believe that nothing is more, well, this is an exaggeration perhaps, but we think the accelerated or the end of coal-fired generation in North Carolina is extremely foreseeable. And we think that we should be dealing with something so foreseeable at this point in time. An accelerated depreciation of this fleet would allow us to match the expected life of the asset to the expected depreciation rate. And it would also help us avoid a stranded asset situation, which is really not good for any stakeholder at the end of their useful lives. So we believe that the accelerated depreciation of the coal fleet carries those virtues, and we support it very strongly.
Chair. Thank you, Madam Chair. I don't have any further questions.
All right, I believe Commissioner Clodfelter, you had an additional question.
Sure. Thank you, Madam Chair. I want to pile on to the request that Commissioner Duffley made. And if it sounds like a conspiracy, well, it sounds like whatever it is. In addition, for the company and for Ms. Downey, in addition to the analysis of the on the revenue requirement effect of using some of EDIT to offset some of the coal ash costs requested in this case, I'd like to see a second scenario. And what happens to the revenue requirement if some portion of the EDIT were used to offset, in what I call the Crystal River manner, to offset the accelerated retirement of the coal plants as proposed by the company in this rate case. So how would the revenue requirement change, if at all, if some of the EDIT were used to offset the additional depreciation expense to retire those coal plants on the schedule the company is now proposing? That would be scenario number 2.
All right, thank you, Commissioner Clodfelter. All right, we will take questions on the commissioner's questions, beginning with the public staff.
No questions.
All right, Attorney General's office.
No questions. Thank you.
Any additional interveners have questions on commissioner's questions?
Chair Mitchell, if I may, please.
Mr. Page, you may proceed.
Again, this is for Mr. DeMay. I think I understood you to say in response to some of Commissioner Clodfelter's earlier questions that in the process to come between this rate case and the next Duke rate case, there's going to be a fairly deep dive into the areas of cost of service studies and rate design, and that in that process, Duke welcomes the input of all stakeholders. Did I correctly understand that?
If you're referring to the low-income collaborative, we have a couple of things going on. I'm not sure which one you're referencing, but at one point in time, I was talking about the Low Income Collaborative, where we would be looking at all kinds of measures that will achieve structural change in support of low-income customers. That could include rate design and cost of service type enhancements or changes. I didn't mention, but I feel an opportunity to now, that we are conducting a rate design study as a company, and we will be doing that over the next year or so. There'll be more said about that by witness Lon Huber on the rate design panel.
Yeah, I guess to get directly to the point, I represent a pretty good sized stakeholder, and we would like very much to be a part of whatever conversations Duke is willing to entertain in those areas of cost of service and rate design between now and the next case. Is Duke willing to do that?
Of course we are. It's supposed to be a stakeholder led process.
Thank you very much. That's all I have.
All right, additional questions on commission's questions?
Chair Mitchell, this is David Neal.
Mr. Neal, you may proceed.
Thank you. Good afternoon, Mr. DeMay. I'm David Neal, representing the North Carolina Justice Center et al. How are you doing this afternoon?
I'm well, thank you, Mr. Neal.
Good. To first follow up on some questions raised by Commissioner McKissick regarding the sustainability goals, you would agree, would you not, that improving the grid's ability to integrate clean, renewable energy resources is an important part of achieving the company's and the state's carbon reduction goals?
I would agree with that.
Would you agree that the elements of the grid improvement plan reflected in the second settlement with the public staff and in the settlement with my clients and the North Carolina Sustainable Energy Association include elements of the grid improvement plan that will facilitate integration of clean renewable energy?
In fact, the amount of the grid improvement plan that was settled upon is almost exclusively for the integration of distributed energy resources. There's some cyber investment there as well, but yes.
And now turning to some follow-up questions from Commissioner Clodfelter's questions around affordability. Did you have the chance to observe, Mr. DeMay, did you have the chance to observe John Howitt's live testimony in the consolidated hearing dockets earlier this week?
Most of it, yes.
And have you had a chance to review his pre-filed testimony?
I did skim it, I would say.
Would you agree that Mr. Howitt has a depth of experience on utility affordability and low-income rate design issues?
Certainly, I would acknowledge he has experience and certainly a passion.
And do you recall that Mr. Howitt supported your call to use a collaborative stakeholder process to be overseen by the Commission before initiating any new low-income programs, including new low-income rate designs?
I do.
And Mr. DeMay, are you familiar with the Helping Home Fund?
I am.
And would you agree that the company's contributions to the Helping Home Fund have provided material improvements to the homes of participating low-income customers?
I would agree with that, and the company is pleased to be a participant in those gifts.
And did you hear Mr. Howitt's support for the company's settlement with my clients and the Sustainable Energy Association, including the company's commitment to contribute an additional $6 million towards the Helping Home Fund and to develop new low-income energy efficiency programs as steps that would be important to improve affordability in the short term?
Yes.
And I take it you would agree with his statements?
With his statements?
Yes.
I didn't agree with all his statements.
I'm sorry. To be clear, agree with his statements and support the settlement.
I agree with those statements.
Thank you, Chair Mitchell. No further questions.
All right, thank you, Mr. Neal. Any additional questions from the interveners on the commissioner's questions? All right, Duke, any questions from Duke?
Yes, Chair Mitchell, I just have a few, and these are specifically to Mr. DeMay. Mr. DeMay, do you recall a discussion you had with Commissioner Duffley where the topic of run rates was brought up?
Yes.
Mr. DeMay, did the company recently file a late filed exhibit that dealt with run rate issues?
Yes.
Did you have a chance to review that exhibit?
Yes, I did.
Can you describe the exhibit and the major conclusions you drew from it?
Yes, I'd be happy to. Thank you. So the exhibit was born from a request of Commissioner Duff, who asked if we would do a pro forma analysis of what our FFO metric in 2019 would have been had we been awarded a run rate in the rate the 2018 rate board. And Schedule A in that exhibit describes that calculation, that analysis. And I want to just point out a few things to think about as you consider Schedule A. One is the run rate was requested for and is always contemplated to be a recovery of costs on a prospective basis. So we were not seeking to recover historic spend with a run rate. And so in 2018, had the order approved a run rate, and we were looking to adjust the 2019 FFO metric, we simply changed the treatment of 2019's coal ash costs from a capital-like treatment and called it more of a period expense. And in so doing, we adjusted the metric. And the way that occurs is coal ash, when it's being capitalized and deferred, is not part of our FFO numerator. It is not an operating cash flow item because it is being treated like capital. And so we have to then add that back in because a run rate implies that it's no longer being treated like capital. So we added that cost to FFO and reduced it. But then the way a run rate would work, we would increase the revenues to FFO to reflect the allowed run rate. And so you can see on Schedule A, we'll just look at DEC, that once the commission would make the move from capital treatment to O&M or an operating cost, then the rating agency would treat all coal ash expenditures as an operating expense. And therefore we took out $278 million. We put in 201 because that was the 2017 run rate. And you can see that while we are able to recover through the run rate revenues a good bit of the total coal ash spend, we didn't recover all of it. And therefore you can see a relatively modest reduction in the FFO to debt calculation. So there are three lessons, I would say, that you can take away from that one exhibit. One is the test year does not necessarily equal future spend. I know that's intuitive, but you have to set a run rate that approximates the coal ash spend that you expect to incur if you want that metric to be supported. The other thing I would say is that when the rating agencies changed their view of this as a result of moving to a run rate, They're going to take system-wide coal ash costs and put them back as a deduction to FFO, system-wide. But of course, this commission would only be able to grant a run rate on the North Carolina retail portion. So there will be South Carolina components, there will be wholesale components. So those, again, not necessarily the purview of this commission, but just for context. It will be hard for a run rate to completely offset the change in treatment by the rating agencies, but you can get close. The third is that, that mismatch that I'm describing here, the mismatch you see here in this pro forma calculation, creates a bit of lag in and of itself. And you would have to establish some kind of deferral mechanism to where under collections are dealt with or over collections are dealt with. So this was in response to Commissioner Duffley's request. But if I could take you to Schedule B for a moment, the company went a step further because it's important to understand the trade-offs of the different recovery mechanisms. And I want to start with the predicate that coal ash is a recoverable expense. You have to start there to embrace this, this table and the calculations that we're making here. If coal ash is accepted as a recoverable cost, then it is either in current expense being paid for by current revenues, or it is a current expense being deferred as a deferred expense and then recovered over time by a commission decision in a future rate hearing, or is treated as a capitalized regulatory asset that will actually function very similar to the deferred cost. And so one of two things has to happen in order for the company to recover its costs, its prudent costs. Let's just make that assumption as well, that it is either receiving recovery in the period of the expense, or if it's being deferred or capitalized, then it has to receive a return as well to compensate for the use of shareholder funds. And so I want to just quickly just say what this table does. In the first column, we should have reordered these columns, but the first column and the fourth column, they're numbered, are taking the existing treatment of coal ash from the 2018 order to DEC and to DEP. And the first column is exactly the same treatment with a 5-year flow return and recovery. The fourth column is a extension of that recovery period from 5 years to 10 years. And that is merely taking the request of effectively what's in this rate case today and applying the current treatment with a different amortization period. And you can see that what's intuitive is the longer amortization period has a mitigating impact on customer rates. It's just like taking a 15-year mortgage and refinancing it to a 30-year mortgage. You're getting that benefit of a longer period of time. But what happens in columns 2 and 3 is the run rate concept. And the run rate works for prospective costs, but you still have to deal with the historic costs. And what this table shows is not only are we recovering the current ask through the column 1 mechanism, 5 years, but we're also adding a run rate for future costs. Column 2's run rate is a 2018 test year. Column 3's run rate is an average of the future 5 years. That's the difference between those. But there is almost no difference between the 28 test year spend and the 21 to 25 average spend. And so the story really isn't the comparison between column 2 and 3. They just happen to be very close in scale. The story here is that a run rate is an effective way to recover coal ash costs, and but it will have a dramatically stronger impact to customer rates than the ability to defer or capitalize these costs and set them for recovery at a future date. And even with a return, which we believe these deserve, that will be less impactful to customer rates than the run rate. But importantly, either is a reasonable mechanism for achieving timely recovery. Column 1 is more timely than column 4, and column 2 and 3 are more timely than column 1 and 4. Column 1 is more timely than column 4. You get the point I'm trying to make here. But there's a series of trade-offs here. And we just wanted the commission to appreciate and understand that if you start with that predicate, I suggested that coal ash is recoverable, and if it is using shareholder funds, in other words, not being recovered in the period it is incurred, then the current mechanism is probably the most effective. In the 2018 order, the commission said that we were to continue to defer our costs, that they would be evaluated at the next rate case, and barring any imprudent costs, again, I just want to, for the sake of argument, assume no imprudent costs, then we would be allowed to recover these with a return during the amortization period. And the commission would set the amortization period. And we wanted you to see that a 5-year return and a 10-year return are both credit supportive to the company. So hopefully you're able to follow some of those lessons I think we were trying to convey from this analysis.
Thank you. I have no further questions.
All right, I would, at this point, entertain motions from the parties.
Chair Mitchell, only motion I have is I move to excuse Mr. Larry Hatcher.
All right, hearing no objection, Mr. Robinson and Mr. Hatcher, you may step down. Thank you very much for your testimony today.
Madam Chair,
I'm sorry, and just one, I believe, Ms. Force, you were about to move your exhibits in, but I will allow Mr. DeMay to step down as well for the time being.
Thank you, Chair Mitchell.
Thank you, Mr. DeMay. We appreciate your testimony today.
You're welcome. Thank you.
All right, Ms. Force.
Madam Chair, the Attorney General moves the admission of AGO Hatcher cross exhibits 1 through 5.
All right, thank you, Ms. Force. Hearing no objection to your motion, it's allowed.
Madam Chair, Marcus Strathan for tech customers. I would also move into evidence DeMay tech customers cross exhibit 1.
All right, thank you, Mr. Strathan. Hearing no objection to your motion, it is allowed.
Chair Mitchell, Terry Townsend for the AG's office. I also would like to move into evidence the AGO exhibit, DeMay AGO exhibit 1.
All right, Ms. Townsend, hearing no objection, your motion is allowed.
Thank you.
All right, at this point, we are still with Duke. You may call your next witness.
Chair Mitchell, before we do, if we could have just a minute to be able to get Mr. Immel into the room for him to testify.
All right, thank you, Mr. Robinson. Let's take a 5-minute recess to allow the witnesses to switch places. We will be off the record, and let's go back on at 2:26.
Thank you, Chair.
Testing. Can you hear me? Andrea, can you hear me? There's John.
I can.
I'll move down a little, right there.
John, can you hear me okay?
Yes, you're a little, volume's a little low.
I'm gonna do it somewhere else. Speak on microphone, okay?
raises up.
Yes, thank you. There you go. Take it all the way. There you go.
There.
Yep. Got it. That's all good.
How about now, John? Different?
Much better.
Thank you. Yes, ma'am.
All right, Joanne, are you ready to go? Okay. All right, let's go back on the record, please. Duke, we're with your witness. You may call him.
Thank you, Chair Mitchell. This is Andrea Kells appearing on behalf of Duke Energy Carolinas, and the company now calls Mr. Steve Immel.
Good afternoon, Ms. Kells, Mr. Immel. Mr. Immel, let's go ahead and get you under oath, please, sir. Raise your right hand. Make sure you're not muted. All right. Do you affirm that the testimony you shall give in this proceeding shall be the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you very much, Ms. Kells. You may proceed.
Mr. Immel, would you please state your name and business address for the record?
Steve Emmel, 526 South Church Street, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy. I'm the Vice President of Fleet Transition Strategy. At the time of my direct testimony and rebuttal testimony for this hearing, I was actually the Vice President of the Carolina Coal Generation Fleet.
Did you cause to be pre-filed in this docket on September 30th, 2019, 12 pages of direct testimony?
I did.
Did you also cause to be pre-filed in this docket on March 4th, 2020, 19 pages of rebuttal testimony?
I did.
Do you have any changes or corrections to either of those testimonies?
I do not. No changes.
And if I were to ask you the same questions that appear in your direct and rebuttal testimonies today, would your answers be the same?
They would be.
Mr. Immel, did you prepare a summary of your direct and rebuttal testimonies?
I did.
Chair Mitchell, at this time, I move that the pre-filed direct and rebuttal testimonies of Mr. Immel and his summary of his direct and rebuttal be copied into the record as if given orally from the stand.
Hearing no objection to your motion, it will be allowed.
Thank you. Chair Mitchell, the witness is available for cross.
All right. Ms. Force or Ms. Townsend, you're up first.
Thank you. No questions from the Attorney General.
All right, Mr. Quinn, you're up next.
Thank you, Chair Mitchell. Good afternoon, Mr. Immel. My name is Matthew Quinn. I am an attorney on behalf of NC Warren. I'm going to ask you just a few questions this afternoon. Specifically, I'd like to speak with you a few minutes about Duke Energy Carolina's DFO projects for which it requests reimbursement in this rate case. And when I say DFO, I'm referring to dual fuel optimization. Is that a fair acronym to use, sir?
Yes, sir, it is.
Okay. Now, my understanding is that the DFO projects, which are part of this rate case, are Cliffside Units 5 and 6 and Blues Creek Unit 1. Is that right?
That is correct.
All right. And for these DFO projects, what is the amount of money for which DEC is requesting reimbursement in this rate case?
It's approximately $125 million was the cost to implement at those three units you referenced, Cliffside 5, 6, and Blues Creek 1. And then another about $120 million associated with the capital pipeline lease.
Okay. And these DFO projects, they will permit these units at Blues Creek and Cliffside to burn some combination of coal and natural gas. Is that a fair understanding?
That is correct. A combination, or in fact, Cliffside 6 could burn just gas, 100% gas, as well as Blues Creek. We could get 50% capacity on just gas without any coal. And of course, any combination. Yes, sir.
Now, prior to the implementation of these DFO projects or the DFO construction, these subject units at Ballew's Creek and Cliffside, they were coal-fired units. Is that right?
Yes, sir. Pulverized coal. Correct.
Okay, and they used steam boilers at these units. Is that right?
That is correct. Yes, sir.
Okay. All right. So now we're using these same steam boilers to be fired by either coal or natural gas, correct?
That is correct. Yes, sir.
Okay. Now, would you agree with me, sir, that burning natural gas and steam boilers formerly fired by coal reduces the thermal efficiency of the steam boiler?
There is a very slight reduction in the heat rate, which is a measure of the unit efficiency. There is a small decrease in the efficiency. It's due to the amount of moisture that is in the gas, the fuel. However, when we are not burning coal, it removes a lot of the auxiliary electrical load from the pulverizers, from all the coal handling equipment that pretty much offsets that thermal inefficiency that you described.
Okay, and I appreciate that. And just to make sure I understand, it is in fact correct that these DFO projects reduce the thermal efficiency of the steam boilers at these units, right?
It reduces the thermal efficiency of the boiler component, but the overall efficiency of the generating unit is very minimally impacted, since we are able to reduce the auxiliary loads by not pulverizing coal.
Mr. Amo, I want to ask you a question. I don't think is a controversial question, but would you agree with me that there is a trend in the public utility industry moving away from coal and toward other forms of electricity generation?
Yes, sir, I would agree with that.
Okay. And that trend's been going on for several years now. Is that fair?
Yes, sir.
Okay. Is it fair to say it's been going on for 5 years?
It probably fair to say that, gradually and increasing. Yes, sir.
Do you recall, sir, when construction of the DFO project at Cliffside Unit 5 began?
I do not know the exact month. It went into commercial operation in late 18, so it probably started construction in the spring of 18.
Okay. All right. And okay. And no, that spring 18 is good enough for my purposes. So would you then agree that at least at the time that this DFO project was undertaken, construction was undertaken at Cliffside Unit 5, this trend we discussed a moment ago, moving away from coal, had already begun? Is that correct?
Yes, and as you describe a trend, if I could maybe comment on that trend, what creates the trend is the continued lower price of natural gas, which of course is a benefit to our customers, and also the continued improvement in technology efficiencies of combustion turbines. So you have machines that continue to get more efficient on natural gas, and over this period of time you're talking about, you also have a declining fuel price. Yes, sir. That creates the trend.
Okay. Mr. Emmel, would you also agree with me that at the time that the business decision was made to implement the DFO project at Cliffside Unit 5, the projected retirement date for that unit was 2032?
Yes, sir. The time that we pursued this would have been in the late 2016 timeframe. Yes, sir.
And now, obviously, Duke Energy Carolinas is requesting that the retirement date of that unit be shortened to 2026 in this docket, correct?
That is correct.
So ratepayers are going to have 6 years fewer to reap the benefits from Cliffside Unit 5 DFO than was expected when the project began. Is that fair to say?
That is fair to say. If I could describe some of those benefits, though, that you mentioned, you know, early you asked me the dollar figure of dual fuel. At Cliffside, the investment in dual fuel, and I've got a summary here to my right that I'm looking at. It was approximately $54 million in total. $18 million of the 54, which is a considerable amount of money. That is the amount that was spent on Cliffside 5, smaller. And so since the addition of dual fuel, we've had the ability to start units now on gas versus fuel oil or diesel fuel that was done in the past. So some immediate savings to customers have been realized since when we went commercial with these units.
All right, I have no more questions, Mr. Emmel. Thank you.
Thank you, Mr. Quinn.
All right, Ms. Lee.
Thank you, Chair. Good afternoon, Mr. Emmel. I believe we may have met on occasion before, but again, my name is Bridget Lee, and I represent the Sierra Club in these proceedings. I'd like to ask you a few questions today about Duke Energy Carolina's coal fleet, if that'd be all right.
Certainly. Good afternoon.
And that fleet includes 13 coal-fired units at 4 separate plants. Is that right?
That is correct. Yes.
Okay. And of those 13 units, all but one began operating over 45 years ago. Is that right?
That certainly sounds in the neighborhood, yes.
Sure. Subject to check.
Certainly, yes.
Okay. And the Allen plant, where I believe you have some additional history working as a manager, that's the oldest plant in the fleet, and it first came online 63 years ago in 1957. Is that right?
That's correct. Unit 1 and 2, I think, went commercial in 57.
Okay. Mr. Emmel, when does the company expect to retire the Allen Station units?
Well, in this rate case, what we have filed for accelerated depreciation is units 1, 2, and 3 in 24, which is no change. In units 4 and 5, we've accelerated from 28 to 24.
Okay. And in the integrated resource plan the company filed earlier this week, it was indicated that the most economic retirement year for Allen units 2, 3, and 4 was 2022. Am I getting that right?
That is correct. So that was filed just this week, as a matter of fact, September. Yes, that is correct.
Okay. Can you explain to me that difference of 2 years? So with respect to the analysis that was done in the IRP versus, I guess, the depreciation study that gave the company the 2024 date, what changed or what additional factors were taken into consideration?
Well, I guess to begin with, we're maybe a year apart from the time that the filing for this rate adjustment versus the IRP that was just filed. The inputs to these reviews are constantly changing. So there's many inputs into it. So fuel forecast, price of gas, price of coal continues to change. Technology, whether it's renewables, whether it's gas turbine technologies, those prices continue to change. Our load demand forecast also continues to change. So if the question is why did it change, it's a lot of those factors.
Understood. Thank you. Okay, turning to your rebuttal testimony, I am looking at page 9, line 18. And here you state that the company studied the potential early retirement of Cliffside Unit 5 and Allen Station in 2016 and 2017 respectively. Did I get that right?
Bridget, can you hear me? Yes.
Yes, I can now.
Okay.
Oh, great. Okay. So let's turn to Cliffside Unit 5 for a moment, if we may. What was your involvement in preparing the company's 2016 study of the potential early retirement of that unit?
At that time, I really had no involvement of putting the study together.
Okay. Are you familiar with the methodology that was used to conduct that study?
Somewhat familiar.
Okay. Do you know if a capacity optimization model was used to do that study?
I'm not familiar with the term capacity optimization. No.
Okay. Maybe let me take a step back. To your understanding, if you could just describe the methodology in brief, that'd be great.
In that particular analysis in the presentation that of course I had the opportunity to review, even though I was not part of the preparation of it, it was done at a time when we were exploring coal to gas opportunities. We were exploring not just in the Carolinas, across the entire coal fleet that we operate. We were exploring what are those opportunities to economically bring gas in and explore potential retirement of some of the coal facilities. So that was the time frame that this took place. Cliffside was a station that it seemed very feasible due to the location of a gas transmission line. So it was economically feasible to bring in gas to that site to the benefit of the customer. And so as they evaluated the retirement, and at that point in time, and again, this was in late 2016 when they did the analysis. The analysis would include, to your question, the analysis would include what is the cost of replacement capacity at that time that we reviewed. It would also look at what is the investment, the capital investments over the short term that you might avoid if you were to retire early. Those are probably some of the larger inputs. And then we also make some assumptions on what might be carbon legislation in the future. That would be, there's many more inputs than that, but that would be some of the inputs.
Sure, thank you. That's very helpful. Would it be fair to understand with that study, the replacement resource considered was, the company was only considering a gas replacement?
In that analysis, it was studied to be replaced with gas turbines. That is correct. But I would say prior to making that assumption, we go back and look at previous IRP filings. What is the most economical replacement dispatchable resource? At that time, solar and the current battery technology, it was difficult to have those resources referred to as dispatchable. You can't cut them off and you can't turn them on in the middle of the night, et cetera. So that is all weighed into the decision that we picked the most economical replacement for the customer, which at that time, again, was combustion turbines. Correct.
Thank you. And I think you mentioned as part of that study, the folks conducting it would have considered potential cost savings, I guess forward-looking capital expenditures at Cliffside Unit 5 and which of those might be avoided. Is that fair?
That is correct. Yes, ma'am.
Okay. And the company has incurred a number of capital expenditures at Cliffside Unit 5 between that 2016 analysis and the start of these proceedings. Is that right? That
is correct.
Okay. And those would include the the conversion to dry handling of bottom ash, a scrubber wastewater treatment system?
Yes, along with, of course, all the processed water and the stormwater reroutes and retention basins, et cetera. That's correct.
Okay. And did that 2016 analysis consider specifically each of those three buckets of costs and consider specifically the savings that could be enjoyed if those were avoided?
It is my understanding they did. In some cases, and I'm not sure how they separated it, but in some of those cases, with the larger redirection of stormwater and processed water, et cetera, they were also required for Unit 6. So I'm not sure how they segregated those costs, but yes, they were considered.
Understood. And would those pieces of work, were those required under CAMA?
They would be required under CAMA and federal CCR regulation, yes.
Okay. And do you know, is the CAMA deadline for ending discharges of bottom ash transport water, is that a sooner deadline than the deadlines in the federal rule?
You are, that question is certainly better answered by witness Bernardsick, but my understanding is at Cliffside, our compliance date was in 2019.
Okay. And this is a question I asked Mr. DeMay this morning, and he thought you would know the answer. Did the company seek, actually, I should take that back. I asked him this question with respect to the Allen plant, but I'll ask it to you with respect to Cliffside Unit 5 as well. Did the company seek any variance of the CAMA deadlines for that plant?
It's my understanding at Allen Station, because it's one of the exhibits, of course, we did explore a variance. I'm not too sure to what extent it was explored, but the short answer was it would not be supportive. And Jessica Bernardsick, and I hate to push your question off to another witness, but she is very familiar with the variance process that DEQ uses in terms of this. So I think she would have a much better answer.
Okay, no problem. And I think I'll have some questions for you about Allen in a moment, but just to stick with Cliffside 5 for a second here, do you know whether or not the company sought a variance from the CAMA deadlines for that unit?
I do not know.
Okay, we can ask Ms. Bernardsick. Aside from those environmental compliance costs that we mentioned, would there be other capital expenditures expected over the remaining lifespan of Cliffside Unit 5?
Certainly. There will certainly be what we refer to as major inspections, major generator inspections over the life of the unit. Those possibly would not take place if it was retired early. We also looked at, potential new water regulations that might require capital investment. So those would be part of that potential savings if we had retired early.
Thank you. Mr. Immel, are you familiar with this commission's August 27th, 2019 order in the company's IRP docket?
I am not.
Okay. Let's talk about Allen quickly. Your testimony also pointed to an early retirement analysis that was conducted for the Allen units in 2017. Is that right?
Correct. Yes, ma'am.
And did you have any involvement in preparing that study?
I did not. No.
Okay. So is it fair to understand that your knowledge of it is limited to the 6-page slide deck and appendix that the company has made available during discovery in this case?
I'd say that's fair to say, yes.
Okay. And If you could describe for me a little bit about the methodology of that study, if it was along similar lines, what you described for Cliffside, or was it different somehow?
The similar, very similar. One of the differences would be we were not exploring bringing in a gas pipeline based on location of the closest gas transmission line. Allen was not economically feasible for the customers to bring in an alternate fuel source. So that is different than Cliffside. We were certainly looking at, prior to making a significant investment in the environmental systems to comply, which would be, as you mentioned before, bottom ash conversions, rerouting of processed water, storm water, lined retention basins, and also some improvements on our wastewater treatment facilities, a significant amount of money. So we conducted the analysis just to see is what's the potential if we could retire earlier to avoid some of that capital expenditure.
Okay. And in conducting that analysis, was the company looking at a number of different alternatives, or was it limited to replacement generation that would be gas fired, as we saw in the Cliffside study?
It would be similar to my response on the Cliffside study. And Allen would have also an added complexity based on its location, in terms of its location on our grid, on our transmission system. It's critical to have 100 kV generation at that point in the transmission system due to some voltage support concerns. So it had the added complexity there versus that at Cliffside.
Okay, thank you. Mr. Immel, in the 2020 IRP that was filed this week, Allen units 2, 3, and 4 were designated with an earlier assumed retirement date. And in that document, the company indicated that those units would be able to retire by 2022 without any additional transmission or generation. Is that correct?
That is correct. So units 2, 3, and 4 are connected to the 230 kV transmission system.
I see.
Actually, 3 and 4 are connected to the 230 kV system. Units 1, 2, and 5 are connected to the 100 kV. In support of our transmission switchyard project in replacement of these auto bank transformers, transmission is requiring 2 100 kV connected units, and the company is picking out 1 and 5 in particular. Yes, ma'am.
Understood. Okay, so that would account for the transmission needs you mentioned in being highlighted in the early retirement study, and why those wouldn't be a problem at with respect to the units retiring by 2022. If I'm understanding you correctly.
Correct. Of course, at the time of the analysis, which is approximately 4 years ago, there was a need for capacity replacement. Fast forward 4 years, looking at all the variables I mentioned earlier, per this recent filing, the long-range planning would suggest capacity replacement is not required now. Correct.
Thank you. And is that diminished need for capacity, is that a function of additional generation resources that have come online, or a drop in demand, or something else?
I would say it's everything you just described. We certainly have added new transmission or new generation sources, including renewables, and of course, demand is certainly a function of that as well. Yeah.
Thank you. I'm looking at, and I don't think you actually need to turn here, but I'm looking at page 6, line 11 of your direct testimony, where you've identified 689 million of capital investments for the coal fleet. would you say approximately 100 million or so of that number was spent on Allen plant retrofits?
I would actually say it's more than that.
On that, okay.
The roughly $690 million that is referenced in my direct testimony, that was in fact systems that were put into service at all four of the coal facilities, as you described earlier, in response to the new environmental regulations, CCR, CAMA, as well as the steam effluent limitation guidelines. And so of that 689, approximately 150 million was spent at Allen Station.
Okay, great, thank you. And of that 150 million, would some of those costs be more routine maintenance at the boilers and things of that sort, as opposed to the regulatory compliance costs?
No, that 150 million is all around the environmental cost. And I might add, roughly 70 million of that 150, it would have need to be spent irregardless if we retired the unit in 17 or not, because we had to cease flows into the current ash ponds, which would require us to reroute processed water, stormwater flows, line retention basins. So of the 150 million, 70 million was going to be spent irregardless of retirement. So as you ask about what about other maintenance costs, in this current proceeding in our request, approximately $15 million was spent at Allen in terms of what I refer to as maintenance capital.
Okay, thank you, Mr. Emmel, for that. The 70 million for ceasing flows, that was required to be spent under CAMA?
Well, I think I'm going to answer then. I think more details will go to Jessica, but
sure.
CAMA and CCR carry a lot of the same regulatory requirement. I think CAMA probably drove some of the schedule, but very similar regulation.
Okay. And again, I think you've mentioned that Ms. Bedarczyk probably has more detail on this, but is it your understanding that the company did seek a variance from DEQ with respect to the Allen CAMA deadlines?
I'm not, what was shared with me is DEQ would not be supportive of a variance. Whether or not we requested the variance, I think Jessica can help with that. She actually can help with the whole process on how you go about requesting variance.
Okay.
So I think we had determined they were not supportive of a variance.
Okay, thank you. Yeah, so we'll put aside the details of what a request like that might have looked like. But from your perspective, if a variance had been requested and had been approved, would early retirement of any of the Allen units then have been viable?
I object to the question calling for speculation.
All right, Ms. Lee, what's your response, please?
Yeah, I'm interested in Mr. Immel's understanding of what decision making goes into an early retirement study of this sort. If this is one of the main factors, I think it's important to understand, if it had been approved, what the study could have looked like.
All right, I'll let the question, I'll overrule the objection and let you proceed with your question, Ms. Lee.
Could you ask it one more time, please?
I sure could. If a variance was approved, would the early retirement of any of the Allen units have been viable?
And this is speculation, but I've been asked to speculate. I'm going to say it would not have been viable for many of the reasons we've already talked about. We had transmission constraints, as we still have transmission constraints, as you mentioned in the current IRP filing. So We could not retire due to transmission constraints. We could not remove all that generation from the 100 kV system. And then also the variance, it really would only address a portion of the cost around bottom ash conversion. The variance would have nothing to do with removal of the processed water, the stormwater flows, getting out of the retired ash basin. Those costs were going to take place. So the variance would really address maybe some optionality in our bottom ash system is really all that it would address. So if I were to speculate, I do not think we would retire early. I think and looking backwards, I think we made a very sound decision, probably the same decision we would make today.
Okay, thank you. And in reaching the decision that was made, did the company consider whether the plant would be fully depreciated by the proposed retirement date?
But we certainly looked at what would be the net book value that would be, left at the time of retirement. We certainly look at that, but that is not part of the economic analysis that was performed. As we mentioned before, all the inputs in terms of what does it cost to replace the capacity, what's the future cost, what's the current cost to meet regulations, all that drives the decision, do you retire or do you invest? When it comes to the net book value, that's just another aside. It's another factor for the executives that make that decision.
Okay, understood. And putting aside for the moment the feasibility of retiring any of the Allen units earlier than 2024, back in 2017, when the company conducted the evaluation of whether or not to invest in various retrofits that we've discussed, did it consider it prudent to make upgrades to the plant that might only be utilized for a handful of years?
Well, when you say prudent for a handful of years, what we were faced with was a considerable investment to remain compliant by a 2019 date, not sure the month, but we were faced with retire it. And if we don't retire it, it was prudent and reasonable. We're going to operate an environmentally compliant fleet. So we had to make those investments. I don't know if that answered your question.
I think that's good enough for now. If you could, Mr. Immel, please turn to your rebuttal testimony, page 13, line 4. Are you there?
Yes, ma'am.
Oh, great. So do you see where you're talking about the company's economic dispatch model and state, quote, utilizes variable costs rather than fixed costs, which are contractually required to be spent whether the units run or not, end quote?
Yes.
So would you agree that there's certain fixed costs would be avoided if a unit were to retire?
Certainly.
Okay. So whether they're considered by the dispatch model or not, those fixed costs would affect the overall profitability of a unit or the net value of the unit.
Well, if I could go back and look at the context of this response and this rebuttal, which is to the Sierra Club witness Wilson's testimony. She's determining, I think in her words, she calls it an economic value of the units. And she uses cost and she uses the energy that the unit produces, the energy, the amount of megawatt hours. And what I'm describing here is Duke Energy operates a fleet, a very efficient fleet of nuclear, hydro, pump storage, solar, coal, gas. It's an integrated system, and there's a capacity value that Witness Wilson did not consider. She put all her cost on how much energy is produced. You know, it'd be an interesting contrast would be pick one of our combustion turbines, which is typically just for cycling, just for peaking, just to be able to have spinning reserve if we lose a bigger unit. There might be some years those units don't run at all. And to put all that fixed cost on those units just doesn't make sense. There's a value in capacity. And I think as she analyzed the Allen station, which is 1,100 plus megawatts, all she was considering was how much energy it produced. In my rebuttal, I'm trying to describe, we operate it as a system, we dispatch it as a system. Yes, there's a fixed cost, but there's also a value in that capacity of that plant. Even if it doesn't run, there's a value.
Okay, but didn't Witness Wilson's analysis show that the company's coal units were in fact more profitable during those peak winter hours where they're being called on for their capacity?
Yes, and again, I think she did the same thing as she picked out those weeks that they might have run and put an energy price on it and calculated the value. But in retrospect, how do you forecast when you need that capacity? That's why we have capacity reserves. We have long range planning reserves, and we have daily operating reserves. So you certainly have to match your generation supply with what the customer's demand is. And to do that, and you have to do it in real time. And to do that, you have to have a certain amount of capacity ready reserve to supply the customer needs. So there's a value of those units when they're not running.
Okay, thank you. I don't have any other questions for you, Mr. Immel. Thank you so much for your time.
Thank you.
All right, thank you, Ms. Lee. Mr. Trefin, you are up next.
Chair Mitchell, this is Craig Schauer on behalf of TEP customers. In light of the questions that have been asked, we do not have any questions at this time, but we'd like to reserve our ability to ask questions on the Commission's questions. Thank you.
All right, thank you, Mr. Schauer. Any additional cross-examination for the witness? All right, hearing none. Any redirect for the witness?
Yes, Chair Mitchell, just a few. Mr. Immel, Mr. Quinn, on behalf of NC Warren, asked you some questions about the DFO or dual fuel optionality conversion projects. Do you recall that conversation?
I do.
And you discussed with him some aspects of efficiency in the units that are impacted by those projects. Do you recall those questions?
I do, yes.
Could you explain a little bit more what the company's reason and purpose was in doing these projects? What are their benefits?
I'd be happy to. And we're pretty excited to be able to provide this to the customer. So by bringing in natural gas to these actually very efficient units, in particular Cliffside 6 and Blues Creek 1, extremely efficient units, the customer gets many benefits. One is we have fuel diversity and fuel flexibility, and we dispatch economically. So if gas prices happen to rise in the winter, then we can burn coal to the benefit of the customer and vice versa. So we're able to fuel switch based on the least cost of the fuel. And then there's a lot of ancillary benefits to this. A coal unit is very slow, what we refer to as ramping with load. So a Blues Creek unit, which is 1,200 megawatts, it can ramp at a rate of about 8 megawatts per minute. So as people wake up in the morning and begin their day and our load ramps up, we've got to follow that load. And of course, the gas turbines follow quickly. The coal plants follow more slowly. It takes a while to ramp. Providing gas at Blues Creek as an example, we've more than tripled the ability to ramp with load. With gas, we can ramp at 25 megawatts per minute in response to not only load, but also our renewable portfolio now. So solar is a good example. It certainly has its place in our fleet, and we're glad to have it. But when cloud cover comes in or a thunderstorm pops up, and if you've got a couple hundred megawatts of solar on and all of a sudden that drops out, and it drops out very quickly with cloud cover, then you've got to fill in the gap, and you've got to fill it in quickly. So being able to ramp these units quicker is important to enable the renewable generation. And then I'll mention a couple more, is our minimum loads on these large coal plants. You take them down to a certain load, and you've got to keep a certain amount of coal in the unit to keep them online. And it's much more economical to keep a coal unit online than to cycle it completely offline, because then it takes a lot of heat to get it started back up. And so to give you an example, a Blues Creek unit on coal, their minimum load is about 350 megawatts. Firing on gas, we can go down as low as 300 and a little bit lower than that even megawatts on gas. So we can keep the unit online at those lower periods of time and be able to ramp it up quicker. So many advantages besides just, and then of course, I think I mentioned, maybe I didn't mention startup. It takes a lot of fuel oil to start these coal units. I'll give you a little thumbnail at Blues Creek. Those are 1,200 megawatt boilers, very big spaces to heat up. If you're doing a cold start, where you actually have to fire an auxiliary boiler to make steam and begin heating the coal boiler up, it takes about 140,000 gallons of diesel fuel to do that. And by replacing that with natural gas, we can save a considerable amount of money for customers just starting these units up. So a lot of advantages by bringing in the gas to these units.
Thank you. And I think you answered this, but I just wanted to be sure. When the company was looking at the dual fuel projects, did I hear you correctly that most of the investment with these projects at the Cliffside location was for Unit 6? Is that correct?
That is correct, yes.
And Unit 6 can actually burn 100% on natural gas. Is that correct?
Correct. So Cliffside 6 can go from 0 to 100% on gas, or any combination of coal and gas. Cliffside 5, the smaller unit, roughly 500 megawatt unit, it's designed for 10% for startup, again, to save the customer money when we start these up. It can certainly start on gas. That's what we've been doing now since we put the systems in. And it can burn up to 10% capacity, its capacity on gas, if Cliffside 6 is running at 100%. If Cliffside 6 happens to be off in a maintenance outage or for whatever reason, we have the ability to bring Cliffside 5 up to 40% capacity on gas, again, to the economic benefit to the customer.
And as we've discussed, you've discussed with Ms. Lee and maybe Mr. Quinn, we all know the company is currently asking to accelerate the depreciation of Cliffside Unit 5 to 2026. Is that correct?
That is correct.
Okay. And so assuming that Unit 5 is retired in the next few years, Unit 6 will remain and can still run on 100% natural gas due to this project, correct?
That is correct, yes.
And Mr. Immel, are there other, and forgive me if you mentioned this and I missed it, is there a benefit related to reduction in carbon emissions from installing these projects at these units?
Certainly is. I think the rule of thumb is the same megawatts from these units in terms of a CO2 footprint. It's a 50% reduction replacing coal with gas. So there's certainly a opportunity to achieve our companies and now the state's clean energy plans. Yes.
And that has to do not only just with burning gas instead of coal, but in terms of startup as well.
Absolutely. Compared to diesel fuel, that's correct.
And can you explain that just a little bit more, with the fuel oil startup for coal?
Right. Again, you're again reducing the amount of CO2 production using clean natural gas versus a fuel oil product. That's correct.
And Mr. Emmel, the company you're aware, aren't you? And I think you referenced this in your testimony. The company conducted cost-benefit analyses in order to see whether it was a good idea to do these DFO projects, didn't it?
That is correct.
And evaluated the costs and benefits of the projects under, multiple gas to coal spreads to see if they were a good idea. Is that right?
That is correct. Yes.
And the results of those studies were the conclusion that these projects were in the best interest of customers. Correct?
That is correct. And we are doing dual fuel at Blues Creek 2 currently and at the Marshall Station. That is correct.
Thank you. Ms. Lee asked you some questions about the retirement studies that were done in the 2016-17 timeframe for Allen and Cliffside Unit 5. Do you recall that?
Yes.
Can you explain to us just a little more, provide a little bit more background about what the purpose of those, what exactly you were comparing in those studies? For instance, with Allen, was it the cost to install required environmental investments versus the cost that would be associated with retiring? Is that accurate?
Yes. So, and I attempted to explain that on Cliffside. So as we look at the retirement analysis, we're looking at the investment that it would take to remain compliant with the current the future environmental regulations that we knew were coming at us. CCR, CAMA, ELG, all those new regulations. So we look at that cost and continue the operations, or do you retire it early? And what has to happen to retire it early? And of course, with Allen Station, at the time we did the analysis, it was capacity replacement and it was transmission constraints. And as we weighed those analysis, it was the prudent decision for the customers were to make the environmental investment.
And sticking with Allen for a moment, you mentioned that there were certain environmental projects that had to be done no matter what was done with the unit, such as lined retention basins and such. Is that right?
That is correct.
And then there were some other environmental investments that the Allen study determined that you didn't have time not to do. Basically, things like the dry bottom ash conversions had to be done, I think you said, by 2019. And there wasn't time to get replacement generation in place by that date. Is that right?
That is correct. If we were looking at retirement, that is correct.
In your opinion, was the company's decision that it made in 2016 to continue to maintain Allen, has that paid off for customers?
It certainly has. I think it was referenced in Mr. DeMay's testimony earlier today. The cold snap in January of 2018, we actually had all 5 units, all 1,150 megawatts on at Allen. For that week to 10 days, they ran at a capacity factor of over 80%, serving, the customers. It's interesting, the weather patterns certainly are changing. Just last October 19, which you'd expect fall weather. If you recall, we had a pretty significant heat snap and we had all 5 units on at Allen again, serving load. And so, as a matter of fact, this July, I look back, at one point we had all 5 units on, but we kept a couple of those units, I think 4 and 5 on for probably over a week, serving those peak demand times. Yes.
Thank you. And just, I guess, to back up a half step to the actual result of the study, the Allen study, as your testimony describes, that study didn't show a compelling case for early retirement. And so would you agree with that?
I would, yes.
Okay. And what we mean when we say not compelling is that, you know, it didn't come out very strongly one way or the other. And then in terms of the economics, then when you add in the timing factor that we've discussed, it wouldn't have been a prudent decision to retire early. Would you agree with that?
That I would agree with that. That's correct.
Just a couple more. You also discussed with Ms. Lee sort of the fixed costs and variable costs of the coal units. Do you recall that conversation?
I do.
And you were talking about capacity value. And can you help us out and just explain a little bit more, you know, what do we mean when we say a unit has capacity value?
So again, I guess to look at the bigger picture, to manage the transmission system, you have to match the generation that you're producing in real time with the electricity the customers are using. If you don't match it, then you have issues with frequencies and voltage, et cetera. So you have to match it. So in terms of capacity, on a daily basis, we look at the weather and we forecast how much generation. A lot of this is historical, but we look at, you know, how much generation typically do we need based on the weather patterns, the time of the year, the day of the week. And then as we plan that, you also plan, if I get into too much detail here, but you also plan what we call a daily planning reserve. You also have to plan for the largest generating unit you have online if you were to lose that unit. You know, if you were to lose a unit, you've got to respond immediately. So that's part of our daily planning reserve. For DEC, that is our Bad Creek Pump Storage Facility, which is roughly 1,350 megawatts thereabouts. So you have to plan for the loss of a generating unit. You also plan for, you can't actually predict the weather. So you add another 300 megawatts is what we use. You have to add that on in terms of daily planning reserves. And then there's another number we put on there for regulation. You've got to be able, you don't know how quick the renewables might drop out based on weather patterns, et cetera. So you've also got a plan to be able to put generation online or bring it offline quicker. So you add all that up together. For DEC, we have a daily operating reserve requirement of a little over 1,700 megawatts. So it's important to recognize that that's a capacity, and Allen Station plays into that as we plan our daily purpose. So again, there's a value in capacity of all these units. Allen Stations, certainly their capacity factors have declined over a period of time for all the reasons we talked about earlier. We have lower gas prices. We have much more efficient technologies that are burning that gas. So you would expect, we dispatch our fleet economically, you would expect the old coal units to start running less because we have more efficient, less costly units in front of them. But it's critically important we have the capacity there. We put those units online to meet the demand, as some of the examples I just gave.
Thank you. And Ms. Lee also discussed with you about Ms. Wilson's analysis, and we don't need to, I don't have too much on that, but she did ask you a question about Ms. Wilson's analysis showing that these units were more profitable during peak hours. In order to be able to run during peak hours, as you just said, the company also has to maintain the units in order so they can be available to run during those times. Wouldn't you agree?
That is correct, yes.
And in your opinion, is the measurement of profitability that the Sierra Club has put forth a valid one in terms of valuing the company's generation units?
No, again, I think they've I certainly appreciate what Witness Wilson pulled together, but that they have not considered anything in terms of value of capacity. So.
Okay. Sorry, go ahead. Okay. And then you had a couple questions about the 2020 IRP and what's in that in terms of readjusted planned retirement dates for Alan. I recognize you haven't spent much time with the 2020 IRP yet, as it was just filed 2 days ago. But and you know that in this case, do you not, the company is proposing to accelerate depreciation of certain units, Allen 4 and 5 and Cliffside 5. Is that correct?
That is correct.
And in doing that, you would agree with Witness DeMay that the company is recognizing these assets are likely going to retire earlier than originally thought. Is that right?
That's correct, yes.
And is that due to a number of factors like the state's goals and Duke's own goals for carbon emissions and gas prices and those items?
Yeah, absolutely. Again, all those factors you mentioned, continued lower gas prices, improved renewable technologies and the cost of those technologies, battery technology continues to improve. For all those reasons, I do find it interesting. So we conducted a retirement analysis on Allen almost 4 years ago now. Probably has been 4 years ago. And then you fast forward to this, to when we filed this rate case last year, and we're wanting to accelerate those units. And now you fast forward from there to the IRP we just filed, and we're continuing to look for opportunities to retire coal in the most organized fashion and economic benefit to the customer. And also meeting the states and our companies' greenhouse gas emission goals. So yes, I think we're all headed in the right direction there.
And you tied those all together very nicely. And do you think that in doing that constant reevaluation and adjustment as needed, the companies allows itself to be more agile and flexible as it moves forwards and the industry changes?
Absolutely, yes. And I would also add, I think we should be proud of this. Ms. Lee had mentioned the age of the Allen units. So the first 2 units came on in 1957. That's 63 years ago. And we're going to land a retirement within a couple of years of that. I'd say that's pretty impressive.
And Mr. Emmel, just based on your understanding of the changes the company's making in its plans for Allen and some other units, in your opinion, does that show that the company is now putting into a plan side of the equation that it's presenting in this case for accelerating those depreciable lives?
Can you ask that again?
Absolutely. You were talking about how the company has, reevaluates its fleet through time. 4 years ago, decided that keeping them maintained was prudent, and in this rate case has proposed to accelerate the depreciable lives, that was the right thing to do. And then as we all know, but haven't delved into much yet, you're readjusting your planned retirement for certain units in the 2020 IRP. Do you recall those facts?
Yes.
And do you think that by the 2020 IRP showing these advanced retirement dates, that lends support to the company's request for accelerated depreciation in this rate case?
Absolutely. I think that's what I was trying to get at in my previous response. That's correct. Yes. I think it does.
And you did so. I was restating it. Just a couple more. Did the company have any other prudent option other than to make these investments in these plants?
In terms of the environmental investments, no, I think we made very reasonable and prudent decisions. Absolutely.
And the company evaluates all of its investments to make sure that they're reasonable and prudent, does it not?
Yes, it does.
And did any party present any alternative that the company had that it could have done otherwise?
Not that I saw, no.
That's all I have, Chair Mitchell. Thank you.
All right, thank you, Ms. Kells. At this point, we're going to take a short break for our court reporter, so we will go off the record. We'll come back on at 3:40.
Commissioner Hughes, can you please turn off your video? Thank you.
All right, let's go back on the record, please. We will take questions from commissioners, beginning with Commissioner Brown Bland.
I have no questions. Thank you.
All right, Commissioner Gray,
No questions.
Commissioner Clodfelter,
Yes, thank you, Mr. Immel. Good afternoon.
Good afternoon.
Just a couple quick things. I'll try to be quick with them. Does the company have underway any project or projects to try to provide some substitution for island 1 and 5 to provide the necessary voltage support to the 100 kilovolt portion of the transmission system?
Yes, sir. That project that I referred to in terms of the switchyard expansion at Allen, it is under design now. Yes, sir.
It's under design. What's the schedule for completion?
It would be completed end of 23 is the current plan, and that would include the replacement of 2 large 230 100 kV auto banks. That's correct.
Well, even though, and there's been some discussion of this, we're talking about something that we haven't even taken official recognition of yet, but it's been talked about, and that's the 2020 IRP. Even though there may be a date earlier than 2023 that's discussed in the IRP, is it correct then that the 100 kilovolt system is still going to be dependent upon Allen 1 and 5 through the end of 2023?
That is correct. That is correct, and it's required during the construction period. There'll be certain configurations in that switch yard that they really need to have reliable connected generation. Yes, sir.
So during the construction period, there aren't any alternatives or substitutes that you could run in on a temporary basis if you were to shut down 1 and 5 earlier?
No, sir, not that I'm aware. No, sir.
Thank you for that. One last question, because this was referred to you. You know Mr. Issa Zarzar?
I do know him. Yes, sir.
Where is he employed? What's his title and his scope of responsibility currently?
Well, he is in the CCP organization, which is where Witness Bernarczyk is, and she can give you much more information. As I understand, his current role is he has a group of project managers for a certain region in the Carolinas that they manage these environmental projects that we've talked about.
Thank you, sir. That's all I have. Have a good afternoon.
Thank you, sir. You do the same.
Commissioner Duffley.
No questions.
All right, Commissioner Hughes.
No questions at this time.
Okay, and Commissioner McKissick.
No questions at this time.
All right, questions on commissioners' questions, starting with the public staff.
No questions.
All right, Attorney General's office.
No questions, thank you.
Okay, any other interveners have questions on commissioners' questions? All right, questions on commissioners' questions from Duke, Ms. Kells?
I don't have any questions. Thank you.
All right, Mr. Immel, it looks like you are off the hook for the rest of the day. You may step down.
And Chair Mitchell, can I just make clear, I'd like for him to be dismissed for the day, but I think he is reserved to be called back later if needed, so not excused yet. Is that right?
That is correct. You may step down, subject to recall.
Okay. Thank you, Chair Mitchell. Appreciate it.
Thank you, Mr. Immel. All right, Duke, you may call your next witness.
Chair, this one's mine. Duke would call Mr. John Spanos to the stand.
All right, Mr. Spanos, there you are. Will you raise your right hand, please, sir? Do you affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you, Mr. Jeffries. You may proceed.
Thank you, Madam Chair. Before we start, for the record, I'd like to indicate that Mr. Spanos is on issues related to his direct testimony, which is essentially his depreciation study. He is scheduled to appear again on rebuttal on a panel with Mr. Doss, where we expect his testimony to focus on CTR, COR related depreciation issues. I just wanted to note that for the record.
All right, thank you, Mr. Jeffries.
Thank you. Mr. Spanos, could you provide your name and business address to the commission, please?
John J. Spanos. My business address is 207 Senate Avenue, Camp Hill, Pennsylvania, 17011.
And where do you work, Mr. Spanos?
I work for Gannett Fleming Valuation and Rates.
And what's your position with Gannett Fleming?
I am the president of the Valuation and Rate Consultants Group.
Thank you. Are you the same John Spanos that pre-filed direct testimony in this docket on September 30th, 2019, consisting of 19 pages, Appendix A and Spanos Exhibit 1?
Yes, I am.
And was that testimony and that exhibit prepared by you or under your direction?
Yes, it was.
Do you have any corrections to your pre-filed testimony?
I do not.
Mr. Spanos, if I ask you the same questions that are set for pre-filed testimony while you're on the stand today, would your answers be the same?
Yes, they would.
And Mr. Spanos, have you prepared a summary of your direct testimony?
Yes, I have.
Madam Chair, we move that Mr. Spanos' pre-filed direct testimony and summary be entered into the record as if given orally from the stand.
All right, your motion is allowed, Mr. Jeffries.
Thank you. And we'd also move that Mr. Spanos' Exhibit 1 be identified as marked.
It shall be so marked.
Thank you, Madam Chair. Mr. Spanos is available for cross-examination. Questions by the commission?
All right. Public staff, you may proceed.
Thank you, Chair Mitchell. Can you hear me okay?
We can, Mr. Dodge.
Thank you. Good afternoon, Mr. Spanos.
Good afternoon.
I'm Tim Dodge with the public staff. The bulk of my questions today will be on the depreciation study, as Mr. Jeffries indicated, but actually the bulk of my questions will be on when you return for rebuttal next week. But there was one specific topic in your depreciation study that was included as Exhibit 1 with your testimony that I'd like to discuss. Do you have a copy of that Exhibit 1 with you?
I do.
All right. Could you turn to page 262? A moment to turn there.
Excuse me, my document doesn't have those specific pages. Would you be able to reference the bottom Roman numeral pages that maybe I'd be able to get to it quicker that way?
Yes, it's Roman numeral 7-193. This is the survivor curve for account 370.02.
Yes, I'm there. Thank you.
Okay. And again, this is the survivor curve for account 370.02, which is meters hyphen utility of the future, correct?
That's correct.
And just to kind of set the stage here, this is the generalized survivor curve for the AMI meter deployment for DEC, is that correct?
That's correct.
And the curve is labeled as a Iowa 15-S2.5. And just to kind of make sure I understand the terminology indicated in that label. So the 15 in that Iowa survivor curve indicates it's a 15-year estimated average service life for this equipment. Is that correct?
That is correct.
And then the S label in the curve means that the curve is symmetric. So, among other attributes, that indicates that in general, half of the assets are going to be retired prior to the average life, and an equal number would be retired after the average term is reached. Is that correct?
I think that's a fair way to portray the curve. It is a dispersion curve and anticipates retirements happening at multiple ages. Yes. And I think, as you can see, the x-axis has a 15 and reaches 50% surviving at that point. So that's consistent with what you described.
All right, thank you. And now if you could turn to the next page, 263 or Roman numeral 7-194. This is the original. This is the original life table that supports the survivor curve we were just discussing, or is represented on that survivor curve as well. Is that correct?
This represents the actual data and exposures that were available at each age interval. That's what that represents. The smooth survivor curve is the estimation of the life characteristics. So you have a life table, which is the original curve, and then the smooth curve is the representation of what is expected for the most appropriate life characteristics of that asset class.
Okay, and that's exactly what I wanted to talk a little bit about, was the data supporting the life table, or indicated in the life table here. So looking at the life table and the age intervals, would you agree that the oldest age interval indicated on the table is 8.5 years, which represents the first AMI meters placed in service by DEC?
You are correct that the age interval 8.5 is the initial assets that were placed in service in this asset class.
Right. And again, so this table from your depreciation study indicates that as of December 31st, 2018, the value or the exposure for each of those age intervals for this property group. Is that correct?
That is correct.
And the table in the middle, or the blank column in the middle, retirements during age interval, that's blank. What does that signify, the fact that that column in the middle is empty?
Based on the assets and their property units, that represents retirements during each age interval. And for the first 8.5 years, we've not had any recorded retirements for each of these age intervals.
All right. And so if you could turn back to the survivor curve on page 262, if you have that in front of you.
Yes,
okay.
I do, yes.
And so that retirements during age interval, that information is indicated, or I should say actually the survivor ratio is indicated in the dashed line along the top of that table, basically at 100% across the top there.
They're actually little squares at each age interval, but you are correct that that represents the original survivor curve that we've seen so far. And obviously what this tells the viewer and those reviewing that is that this is a very young account, that we've had very little opportunity to utilize statistical analysis to determine our estimate, and informed judgment is required for this new technology or new type of asset class.
All right, thank you. And under the curve, though, wouldn't you expect, year 8.5, where we're at for some of these oldest age intervals, some portion of the AMI meter costs to be indicated as retired?
Well, again, we're using judgment, and the expectation is for this asset class, yes, at age 8.5, we would, based on our information and judgment and industry information, we would expect about 10% or maybe 8% of the investment to have been retired at this point in time. However, that does not necessarily mean that you will not get retirements. It's very possible that at age 10, maybe we'll have 20% retirements based on the new technology. So you can't, when you're doing this, you have to take into consideration informed judgment, which includes what others in the industry are doing and what they expect for these types of assets. So the smooth curve is an extrapolation of what we anticipate. And when you have a very short time period and very limited information, the fact that the smooth curve does not match the actual data should not be a surprise. I would have expected when I see others in the industry, when they get to age 9, that there would have been some experienced retirements. We have not seen that yet for these assets.
All right. And so just to confirm that point you just made, the depreciation study presented no data indicating a retirement of any of these AMI assets in this account at this time.
There have not been any experienced as of December 31, 2018. And again, a 15-year average was consistent with what was utilized in the last study and is the most commonly utilized average service life for these types of assets in the industry.
Thank you, Mr. Spanos. I have no further questions.
Thank you.
All right, the Attorney General's office, Ms. Force.
No questions. Thank you.
Okay, the Sierra Club, I believe it's you, Ms. Lee.
No questions, Chair Mitchell. Thank you.
All right, any additional cross-examination for the witness? Any redirect, Mr. Jeffries?
I don't think so, Madam Chair.
Okay, questions from commissioners? Commissioner Brown Bland?
No questions.
All right, Commissioner Gray?
No questions.
Commissioner Clodfelter?
Yes. Mr. Jeffries, I didn't hear you very clearly. Would you say again the topics that you're going to bring Mr. Spanos back on rebuttal? What are those topics? You're on mute. You're on mute, Mr. Jeffries.
Sorry. How about now?
We can hear you.
I think I was pushing the wrong button on my computer. My apologies. Commissioner Clodfelter, Mr. Spanos will be appearing on DEC's rebuttal case on a panel with David Doss, and the anticipated subject of that testimony revolves around the depreciation related aspects of CCR, cost of remediation, which is a subject that only appears in his rebuttal testimony.
Well, thank you for the clarification. I just didn't hear you the first time, Madam Chair. Actually, I did have some questions for Mr. Spanos on that topic based on pages 26 through 36 of his direct testimony, but I'd rather not ask my questions in separate bites. And so if it's okay with Mr. Jeffries, I'll just hold all my questions for the panel when Mr. Spanos comes back. I'd just like to make sure he understands that some of my questions will be based on pages 26 through 36 of his direct testimony, which cover the topic of depreciation for CCR assets.
All right. Thank you, Commissioner Clodfelter. Commissioner Duffley.
I do not have any questions. Thank you.
Commissioner Hughes.
No questions. Thank you.
Okay. And Commissioner McKissick.
No questions at this time.
All right, Mr. Spanos, there is nothing further for you this afternoon. You may step down and you will be recalled later in the proceeding.
Okay, thank you very much. Appreciate your time.
Thank you, sir. All right, Duke, you may call your next witnesses.
Thank you, Chair Mitchell.
I'm sorry, Ms. Downey. I believe Mr. Jeffries, did you have a motion?
I did. We would move Mr. Spanos' Exhibit 1 into evidence, Madam Chair.
All right, hearing no objection, Mr. Jeffries, to your motion, it will be allowed. All right, I'm sorry, Ms. Downey, did you have a question for me? Okay. All right, Duke, you may call your next witnesses.
Thanks, Chair Mitchell. Again, this is Molly Jagannathan, and I represent Duke Energy Carolinas. And at this time, we would like to call the panel of Janice Hager, Michael Pirro, and Lon Huber to the stand to testify as a panel.
Okay, let's go ahead and get them under oath. Let's see, I see Mr. Huber. I see Mr. Pirro and Ms. Hager. I saw you momentarily and you are no longer on my screen. Let's see.
Ms. Hager, I think you just need to turn your camera on. I will, Madam Chair, if you don't mind, I'll just check on her and make sure she's not having technical difficulties.
Okay, please do so.
Chair Mitchell, if you don't mind, if we just take a couple-minute recess, I'll make sure to get her camera turned on. I'm unable to reach her right now.
Okay. Why don't we take a 5-minute recess here for the witness? We'll go back on it. We'll go off the record now. We'll go back on at 4:05.
Great, thank you, Chair Mitchell. I apologize.
She's got my laptop.
All right, I now see Ms. Hager, so we will go back on the record. Let me check in with my court reporter. Joanne, are you ready? Okay, perfect. All right, Ms.
Thanks,
Jagannath,
Chair.
you may proceed. Let's go ahead and get your witnesses under oath before I turn them back over to you. All right, will you all please raise your right hands? Make sure you're off mute. Do you affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. And just for purposes for the sake of those who are viewing this today, Ms. Hager is sitting behind the name tag of Monica Smith. All right, Ms. Jagannath, you may proceed.
Thanks, Chair Mitchell. Sorry, we had to do another laptop shuffle, so I think we're all set. Ms. Hager, would you please state your name and business address for the record?
My name is Janice Hager. My business address is 2049 Mount Zion Church Road, Alexis, North Carolina, 28006.
Thank you. And can you let us know by whom you are employed and in what capacity?
I am president of Janice Hager Consulting, LLC.
And on September 30th, 2019, did you cause to be pre-filed in this docket direct testimony consisting of 19 pages?
I did.
And did you also cause to be filed corrected direct testimony consisting of 18 pages on February 14th, 2020?
I did.
On March 4th, 2020, did you cause to be pre-filed in this docket rebuttal testimony?
Excuse me, I'm sorry. This is the court reporter. I'm having a moment of technical difficulty myself. If I could take just one moment.
All right, we will pause for the court reporter. Joanne,
Thank you.
just let me know, Joanne, when you're back up.
Okay. Okay, I'm back up and set to go. Thank you.
All right, let's go back on the record. All right, you may proceed.
Madam Court Reporter, did you need me to back up and repeat anything, or should we just pick up where we left off?
Sorry. You could just pick up where you left off. Thank you.
Thanks. Ms. Hager, on March 4th, 2020, did you cause to be pre-filed in this docket rebuttal testimony consisting of 24 pages?
I did.
And on April 6th, 2020, did you cause to be pre-filed in this docket supplemental rebuttal testimony consisting of 4 pages?
I did.
Do you have any changes or corrections to any of your pre-filed testimony?
Yes, I have 2 changes to my rebuttal testimony, which are included in the errata page provided with my testimony summary.
Great, thank you. And with the corrections to your rebuttal testimony that are noted in your errata, if I asked you the same questions here today, would your answers be the same?
Yes, they would.
Chair Mitchell, I would move that Ms. Hager's pre-filed corrected direct testimony, her rebuttal testimony as corrected by the errata page, and her supplemental rebuttal testimony be entered into the record as if given orally from the stand.
All right, hearing no objection to your motion, it will be allowed.
Thank you. And I would also move that Ms. Hager's testimony summary and errata page be entered into the record as if given orally from the stand.
Hearing no objection, that motion is allowed as well.
Thank you. And now I'll turn to you, Mr. Pirro. Would you please state your name and business address for the record?
Mr. Pirro, you are on mute.
Michael J. Puro, 550 South Trans Street, Charlotte, North Carolina.
And Mr. Piro, by whom are you employed and in what capacity?
Employed by Duke Energy, Carolina. Capacity is Director of Southeast Pricing and Regulatory Solutions.
And on September 30th, 2019, did you cause to be pre-filed in this docket direct testimony consisting of 25 pages as well as 9 exhibits to that testimony?
Yes, that is correct.
Did you also cause to be filed corrected direct testimony consisting of 25 pages on October 23rd, 2019?
Yes.
On February 14th, 2020, did you cause to be pre-filed in this docket supplemental direct testimony consisting of 4 pages?
Yes, that is correct.
And did you cause to be pre-filed in this docket rebuttal testimony consisting of 13 pages on March 4th, 2020?
Yes.
Did you cause to be pre-filed in this docket second supplemental direct testimony consisting of 3 pages on July 2nd, 2020?
Yes, I did.
And finally, on August 21st, 2020, did you cause to be pre-filed in this docket second settlement testimony consisting of 4 pages, as well as Puro Second Settlement Exhibit 4 and Puro Second Settlement Exhibit 4?
Yes, I did.
Do you have any changes or corrections to your pre-filed corrected direct testimony, supplemental direct testimony, rebuttal testimony, second supplemental direct testimony, or second settlement testimony?
No, I do not.
If I asked you the same questions here today, would your answers be the same?
Yes, they would.
And do you have any changes or corrections to any of the exhibits to your pre-filed testimony?
I do not.
Thank you. Chair Mitchell, at this time, I would move that Mr. Piro's pre-filed corrected direct testimony, supplemental direct testimony, rebuttal testimony, second supplemental direct testimony, and second settlement testimony be entered into the record as if given orally from the stand.
Hearing no objection, the motion is allowed.
I would also move that the summary of Mr. Piro's testimony be moved into the record as if given orally from the stand.
Again, hearing no objection, that motion will be allowed.
Okay, thanks, Chair Mitchell. And finally, I would move that Puro Exhibits 1 through 9 and Puro Second Settlement Exhibit 4 and Puro Second Settlement Exhibit 9 be marked for identification.
They will be marked as pre-filed.
Thank you. And last but not least, Mr. Huber, would you please state your name and business address for the record?
Sure. My name is Lon Huber, and my business address is 550 South Tryon Street, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Business Services as Vice President, Rate Design and Strategic Solutions.
And Mr. Huber, on March 4th, 2020, did you cause to be pre-filed in this docket rebuttal testimony consisting of 8 pages and a 1-page appendix describing your experience and qualifications?
Yes, I did.
And do you have any changes or corrections to your pre-filed testimony, Mr. Huber?
Yes, I have one update that is included in the errata page provided with my testimony summary.
And with the correction to your rebuttal testimony that was included in the errata, if I asked you the same questions here today, would your answers be the same?
Yes, sir.
Mitchell, I would move that Mr. Huber's pre-filed rebuttal testimony as corrected in the errata page and Appendix A, as well as his testimony summary, be entered into the record as if given orally from the stand.
Hearing no objection, your motion is allowed.
Thanks, Chair Mitchell. The panel is now available for cross-examination.
All right. Public staff, you're up.
Good afternoon to the panel. My name is Diana Downey with the public staff. With me this afternoon is Lucy Edmondson. I will be directing my questions to Ms. Hager, and Ms. Edmondson will be directing questions to Mr. Piro. Mr. Huber, you're going to be off the hook from us for this time. Ms. Hager, I want to turn to your rebuttal testimony. Specifically on page 5, you refer to the National Association of Regulatory Utility Commissioners, known as NARUC, Electric Utility Cost Allocation Manual, and you refer to it as a CAM, I believe. Correct?
That's correct.
And do you agree that that manual was produced in 1992? Isn't that right?
I do.
Have you heard of the Electric Cost Allocation Manual published in January of this year by the Regulatory Assistance Project, or RAP?
I have.
What's your familiarity with it?
I have, it was referenced by a witness Wallach in his testimony the past year or so, and I have reviewed it and spent a little time with it. I'm certainly no expert on it, but I have spent some time with it.
Understood. Chair Mitchell, I'd like to mark Public Staff 41 as Public Staff Piro Hager Cross-Examination Exhibit 1. And this is the manual we were just discussing.
All right, bear with me one moment, Ms. Downey, while I access the document. The document will be marked Public Staff Hager Cross Exhibit 1.
And Chair Mitchell, I think we're marking these Piro Hager since
Okay.
we're addressing these to the panel.
All right. The document will be marked Public Staff Piro Hager Cross Exhibit number 1.
Ms. Hager, do you have that in front of you?
I do.
And I just have one question about this. Would you agree that it's fair to say that the authors of this manual suggest a different approach to aspects of cost of service allocation than the approach used in the CAM?
They do suggest a number of different approaches from what's used in the CAM. Oftentimes, interveners will suggest different approaches. In this case, the manual, which is put out by the Regulatory Assistance Project, comes from a very specific viewpoint of wanting to encourage energy efficiency and distributed energy resources. And therefore, the manual is definitely favors policies and methods that would drive that.
Understood. In your rebuttal testimony on page 23, do you have that in front of you?
Just give me just a second.
Sure.
Okay, I have it.
And I'm specifically referring to your discussion and your response to Mr. James McLawhorn's recommendation that the commission direct the company to study the allocation of grid improvement plan investments. And your response, as I read it, is that any allocation based on perceived benefits realized by customers is likely to be very subjective and controversial. Did I state that correctly?
Absolutely.
Acknowledging that there are differences in opinions on this issue, what's the harm in a study that could potentially resolve or at least result in a better understanding of this issue?
I just don't believe that it is an effort that's likely to yield fruit. And I think the concept of allocated costs based on benefits has so many downfalls that to go forward with it would simply, I think, actually just be a waste of time. If you'll The,
I think I'm just asking you, what's the harm in a study?
mhm. And I think
Please
that,
talk about it.
so I believe, as I said, I think the harm in a study is I don't believe it would produce anything that would be useful for the purposes of cost of service. I do think there's a place for looking at benefits, and that's where the company has done it in this case, which is in deciding what what projects to pursue and what how to prioritize those projects. I think where to try to allocate costs based on benefits is first of all very much a departure from traditional cost allocation methodologies. It is if you think about what we do in cost of service, we essentially look at we have generation, transmission, distribution, customer costs, and then we're looking at how customers use that electricity, what their actual load is. And then we say, okay, how did that load cause costs? We don't look beyond the meter to say what benefits those customers receive. I think if you start doing that, I think there's a real question of, where do you stop? How do you measure those benefits? I think we'd all agree what we've heard in this hearing is that there's a lot of different opinions on what those benefits would be. I would suggest they change frequently. I think they would be lots and lots of different arguments on how to quantify those. And I also think if you think about what Mr. Oliver talked about in his testimony, he made pretty clear that the Grid Improvement Program is a program that addresses a lot of things. It's designed to address the megatrends. And it happens, as he would say it happens to be a program that also provides some reliability benefits. And those benefits happen to be something that can be most easily quantified for commercial industrial customers. And that's not to say that there aren't benefits for residential customers. They're just more difficult to quantify. Benefits are convenient for the purposes of selecting projects, but I would suggest that they really don't have a place for the purposes of cost of service.
I think you just made my point, so I'll just move on. I'd like to mark another exhibit, please. Chair Mitchell, I'd like to mark Public Staff 37 as Public Staff Puro Hager Cross-Examination 2.
All right, the document will be so marked.
Ms. Hager, are you there?
I am.
Can we agree this is the settlement agreement between the company and Sigford 3?
It is.
Are you familiar with this document?
Yes.
Let's look at page 4, paragraph 3B.
Okay, I'm there.
So in this paragraph, the company agreed it will propose to allocate GIP costs consistent with distribution allocation methodologies proposed in this docket in the next rate case. Did I represent that correctly?
Yes.
Now, do you know what the current distribution allocation methodologies would result in what percentage of GIP costs being charged to residential and small general service customers?
I do not.
Would it surprise you to know that under the current distribution allocation methodologies that 64% would be allocated to residential customers?
That wouldn't be surprising.
And that 10% would be allocated to OPT, large commercial and industrial customers?
That's probably a number I would be less familiar with in terms of the percent.
Do you think it would be smaller than that? Or much different from what I just represented to you?
I don't have any reason to believe it would be much different.
Okay, thank you. Let's turn to the same stipulation, 5A.
I'm there.
Okay, thank you. And in this paragraph, the parties agreed to meet to discuss potential cost of service methodologies, and also requires the company to file the results of a class cost of service study with production and transmission costs allocated on the basis of summer-winter coincident peak method, and consider such results for the sole purpose of apportionment of the change in revenue to the customer classes. Did I read that correctly?
Yes, you did.
Isn't it true that the use of a summer-winter coincident peak would, relative to summer coincident peak, allocate more production and transmission costs to lower load factor customers, such as residential customers, and fewer costs to higher load factor customers?
Yes, that's correct.
And finally, let's look at 5B on page 5. And in this, yes, in this provision, it requires the company to adjust its peak demand to remove curtailable non-firm load, even if it doesn't call it. Is that right?
That's correct.
Now, during the test year in this case, the company did not activate DSM during either the system summer or winter peak, right?
I don't recall.
Do you have any reason to doubt that?
No.
If that's the fact, if that's true, isn't it also true that if you did not, there was no impact of DSM on the cost allocation factors in this case?
Let me think about that a moment.
Okay.
Would you restate the question, please?
Sure. Let's assume that Duke did not activate DSM during either the system summer or winter peak. Okay. If that's the case, then there would be no impact of DSM on cost allocation factors in this case.
I believe that's correct.
Thank you. Similarly, it's my understanding that the company did not call on their curtailable customers to curtail either at the system summer or winter peak. Is that right?
Again, I would not know, but I will take your word for it.
Okay, thank you. It's what Mr. Floyd told me. If that's the case, and by not doing so, then there was no impact of curtailable load on the cost allocation factors in this case, right?
That's definitely true for the test year cost of service. I don't recall that any adjustments were made.
Okay. Isn't it true that adjusting peak demand as agreed upon in this provision with SIGFR would result in reducing the amount of production plant allocated to industrial, i.e. high load factor customers, and increase the amount allocated to residential and commercial customers, that is low load factor customers?
I can't say definitively right now. The settlement speaks to curtailable / non-firm load, but it doesn't specify specifically which curtailable non-firm load. To the extent that residential curtailable load was included in that, I believe that the residential curtailable load is probably lower than the commercial industrial curtailable load. And if that is the case, then it would result in more costs being allocated away from commercial industrial.
Thank you, Ms. Edmondson. We'll now question Mr. Pirro. Thank you, Ms. Hager.
All right, before you begin, Ms. Edmondson, we've come to the end of the day, so we will go off the record. And just as a reminder, we will be back on tomorrow morning at 8:30. Please don't forget to join. The line will be open beginning at 8 o'clock. Join as early as you are able to. Thank you.
Hey, John, can you hear me all right? Is my volume loud enough just for tomorrow?
Yeah, it's good.
Okay, great. Thanks a lot.
Sure.